So good afternoon, everyone. We are going to start within like 5 minutes. So just hold on. And if we are you all are able to hear me properly?
Yes, sir.
Hello.
Gupta sir, are you able to hear me properly?
No, I can hear you, but am I audible to there?
Yes, sir. Yes, sir.
Yes,
Both of
sir.
you are 100%
Yes,
audible.
sir.
Ritesh ji, you are also audible.
Thank you so much, Subhash.
Thank you, sir.
Yeah, हाँ ठीक कर रहा है.
तो अनम्यूट करेंगे जब भी अपना खत्म हो गया वापस को म्यूट करेंगे.
Good morning, I am Dr. Mangal.
Good morning, Dr. Gupta Sahab. Good morning, sir.
Yes, sir.
Good morning, Manan also.
Jayesh ji,
Good morning.
कैसे हैं?
Good morning. Good morning, Dave sir. Good morning.
Good morning. Good morning, sir. Good morning, Mangal sir. Good morning,
Yes,
sir.
sir. Yes, sir. Good morning,
Sir, good
everybody.
morning.
Yes, sir. Yes, sir.
Dave sahab,
Good
welcome,
morning.
welcome, Dave sahab.
Thank you very much, sir. You also too welcome.
Ritesh sir. Good morning, sir. Ashish ji, good morning.
Jay sir, are you able to hear me?
Yes, yes, you are audible. Audible.
Yeah, very good, sir. So, sir, within 5 minutes we will start. We are waiting for like Sharma sir to join. Yeah, already he has joined. Okay. So, shall we start this program? Jay sir?
Yes, sir.
Dave sir?
We can wait 1 or 2 minutes more so that
Okay, sir.
more audience may join.
Okay, sir. Getting, sir. We'll wait for 2-3 minutes.
2 minutes at least, 2 minutes.
Yeah,
Not
sir.
enough.
Getting. No issues.
पिछोला में डूब रहा ना
Good afternoon, everybody.
Sir,
Ritesh, why?
sir, good afternoon.
Good afternoon, sir. Good afternoon.
गुड आफ्टरनून शर्मा सर
Sharma sir, are you able to hear us? Sharma sir का open करो.
Ritesh, sir, we should start now. So Ritesh, sir, mute है आपका.
Sir, Sharma sir, recently he has joined and then he left. So we are waiting for him.
Okay. Right.
rejoin.
Right.
And now he again came, so we have to give rights.
थोड़ी लाइटें 2-3 और जला देना यार ये सारी अंदर थोबड़ा नहीं दिख रहा है क्या अंधेरा आ रहा है नहीं आगे वाली चाहिए ये वाली जलाइए ये वाली जला दे, इससे हो जाएगा काम। सर के पीछे इधर से अब रोशनी लगी सर, ऐसी जो है बिजली की चमकार जो है, रिन की फटकार की तरह से।
Ritesh sir has joined already. Ritesh sir, now we can start.
Sharma sir, are you able to hear me? Sir, you are on mute. Sir, I think there is some problem from Sharma sir side. He is not able to join, or I think he is not able to hear us.
Ritesh, I think now I am connecting through my phone. I think there is some problem in the laptop.
Okay.
So I'm now connecting through my phone.
Yeah. So this is nice, sir. We are able to hear you. So Dave sir and Sharma sir, shall we start the show?
Yes, we can.
Yeah. So very good afternoon, all of you. So behalf of Pacific Research and Innovations Promotion Board, I am welcoming all participants and speaker for this one-day workshop on IP protection and patent filing. So this is the program today we have launched, and I just elaborate about the Research and Innovation Promotion Cell aim and their objectives with respect to the IP awareness activity. So I am just elaborating. It is a newly formed cell, and we are continuously striving for promoting IPR activities across the India or globally, also doing all the efforts to make the better ecosystem for researchers and students, which can contribute to make in India as a global knowledge center hub. So with this line, I'm just inaugurating this session and starting this session, and we will have our leaders. They will have the inauguration note, president note from their side. In today's program, we are going to have conduct an online workshop on IPR protection and patent filing, where our speakers are going to demonstrate live e-patent filing with the Indian Patent Office e-portal. And in the second session, we are also going to cover how to draft the Indian patent applications and their critical integrities and on the patentability part. And we'll also have various training exercises where we will see how to draft the claim for the different subject matters in Indian style patent, where people are filing patent here in India, or they are looking for the international patent filing. So with this word, I am just handing over this conversation to our president, Dr. KK Dave sir. So now, sir, it is over to you, sir.
Thank you, Ritesh sir, for the nice introduction. Respected Professor BP Sharma, patron and the group president, Planning and Control Pacific Group of Universities. And today's keynote speaker of this online workshop, Professor A.P. Gupta, sir, Honorable Vice Chancellor, Pacific Medical University, Dr. M.M. Mangal, Principal, Pacific Medical College and Hospital, Mr. Pratik Srivastav, Professor Hemant Kothari, Dean PG Studies, Professor Jayesh Dwivedi, Professor Ritesh Agrawal, convener and host of this workshop, all Dean and Directors, faculty members, delegates, and researcher. I wish to present my gratitude to and welcome to each one of you in online workshop on IPR protection and patent filing. The Research and Innovation Promotion Board, Pacific Group of Universities, working for enhancing research and innovativeness, and hence this workshop is conducted to literate the interested mass. Intellectual property rights have been creative expressions based on which there is a public willingness to bestow the status of property. IPR provides certain exclusive rights to the inventors or the creators of that property in order to enable them to reap commercial benefits from their creative efforts or reputation. There are several types of intellectual property rights we know, as it is patent, copyright, trademark. Patent is recognized for an invention which satisfies the criteria of global novelty, non-obviousness, and industrial applications. IPR is prerequisites for better identification, planning, commercialization, rendering, and thereby protection of inventions or creativity. Each industry should involve its own IPR policies, management style, strategies, and so on, depending on its area of specialties. Pharmaceutical industry, and especially we are talking about medical industries, currently has an evolving IPR strategy requiring a better focus and approach in the coming area. There has been quantum jump in research and development, cost with an associated jump in investment required for putting a new technology in the marketplace. The stakes of the developers of technology have become very high, and hence the need to protect the knowledge from unlawful use has become expedient, at least for a period that would ensure recovery of R&D and other associated costs and adequate profit for continuous investment in R&D. IPR is a strong tool to protect investment, time, money, efforts invested by the inventors, creators of an IPR, since it grants the inventors, creator an exclusive right for a certain period of time for use of this invention and creation. If we talk about impact in the pharma and medicine and related IPR issues, we know that the race to unlock the secret of human genomes has produced an explosion of scientific knowledge and spurred the development of new technologies that are altering the economic of drug development. Biopharmaceuticals are likely to enjoy a special place, and ultimate goal will be to have personalized medicine, as everyone will have to their own genome mapped and stored in a chip. Doctors will look at the information in the chip and prescribe accordingly. The important IP issues associated would be the protection of such database of personal information, biotechnological development. Drug will be, more and more entry into the market. The protection of procedure of such drug will be little different from those conventional drugs, which are not biotechnologically developed. By microbial strains used to developing a drug or vaccine need to be specified in a patent document. If the strain is already, the situation is simple. However, many new strains are discovered and developed continuously, and these are deposited with International Depository Authority under the Budapest Treaty. While doing a novelty research, the database of these depositories should also be consulted. Companies do not usually go for publishing their work, but it's good for make it a practice not to disclose the inventions through publication or seminar until a patent applications has been filed. I will not take much more time because, like keynote speaker is there, Professor B.P. Sharma Sahab and A.P. Gupta Sahab will enlighten more about this topic. So looking to this importance of the IPR in the competitive world, we must get more knowledge about it so that inventions can be patented and we should all get benefit. Hence, this workshop will give insight about how to file patent, and we will learn about basic fundamental related to patent. I think I must admire the efforts of Professor B.P. Sharma sir, Professor A.P. Gupta sir, who has really taken, pen to organize or to conduct this kind of workshop. And definitely convener Ritesh Agrawal, Professor Ritesh Agrawal is here. He is also expert in IPR issues. So I think so the workshop will be going to very interesting and we will learn a lot of things out of it. Thank you once again for giving this opportunity.
So thank you very much, KK Dave sir. So it was nice elaboration by you on IP protection, their utilities in life sciences segment, and we are continuously striving for such kind of new ventures and providing IP awareness activities across the India. So we are very thankful for your kind words, and your words and mentorings are very important to us. Thank you very much, sir. So now I would like to request Dr. A.P. Gupta sir, who is Vice Chancellor with the Pacific Medical University. He's a very senior guy, doctor. And with this word, sir, I am just inviting you for inaugural note. So, sir, over to you, sir.
Yes, sir. Good afternoon to everybody. First, my salute to our Honorable Chairman, Shri Rahulji Agarwal. And I salute his leadership because he has been keeping all the universities together. Salute to our Professor B.P. Sharma sir, who is Group Chairman of Research, Innovation and Promotion Board, and who is keynote speaker today. And all the colleagues of Pacific University, Pacific Medical University, all the research scholars, all the faculty members who have joined today. I will not be lying in between Professor B.P. Sharma Sahab keynote for a longer time, but I want to welcome all those who are joining this workshop today. And I take the pride to inaugurate the meeting so that we learn something good. The subject of IPR and patents is a vast subject. And for us doctors, it's a very difficult thing because we never thought in that terms that we have got intellectual property rights and we can patent certain things. Day to day, every doctor is treating a patient with a new way, and he devises certain new algorithms for treating the patient, diagnosing the patient. But nobody has tried till date to patent. And patent in medical sciences is only in 2 points. One is medical equipments, one is pharmaceuticals. Now, research molecules of pharmaceuticals are patented and they are given patent for 10 to 20 years, after which they become declassified. Then same drug which was being sold costly for earning a lot of money for the research fund will be at a cheaper rate to all public. And we are fortunate in India that our patents which expire for different pharmaceutical companies come to India, and we manufacture drugs at such a cheaper rate that is a service to the mankind. Patent of diagnosis of patient, patent of treatment of patients, patent of operations is not possible because we are dealing with a human life and sickness. So that is quite difficult. But today's learning from B.P. Sharma Saab's lecture and Dr. Ritesh and Dr. Prateek, we presume that we will learn the procedure of patents and IPR. And this will help us to file more patents and look for the patents. And every innovation which will come in mind after discussing with the faculty will be attempted to be patented or to be given a clear thought after discussion. I wish you all a bon voyage for a good learning and happy learning. Thank you so much.
So thank you very much, sir, for your wonderful inauguration note. And sir has highlighted a lot of things related to generic and innovating industry in pharmaceuticals. We all know this is the industry we are playing with. India is a global hub. We are a kind of generic manufacturer for globally. And in today's COVID scenario, our recognition is there globally. And a lot of things we can learn because innovation is something we have to seed in India. so that the way we are growing in generic industry, we should also grow with the innovation or innovating kind of industry, where the big innovators comes like Pfizer, big companies. So with this word, thank you very much, sir, for your kind words. And with this note, I would like to introduce VP Sharma sir here, and he's a legend. We all know he doesn't need any introduction, but still he has set a lot of landmark by his efforts, and we need some mentoring and their guidance for this activity. So with this word, sir, I am asking VP Sharma sir to have some discussion or keynote.
Thank you, Dr. Ritesh. The esteemed galaxy of academic and professional luminaries, Professor A.P. Gupta, the Vice Chancellor of Pacific Medical University, Professor K.K. Dave, the President, Pacific Academy of Higher Education and Research University, Professor M.M. Mangal, the Principal, Pacific Medical College and Hospital, Dr. Brigadier R.K. Singh, all the deans, directors, faculty members, and delegates in this webinar. Intellectual property has many times more worth than the physical and materialistic assets of the entire world. And as has been rightly pointed out by former speakers, Professor A.P. Gupta and K.K. Dave, and Professor A.P. Gupta has quoted an example that how prices of various drugs, when they go off patent, fall. Just here, even when the drug doesn't go off patent, but I'd like to quote a case example of Nexavar, the liver and kidney cancer drug, which is being sold worldwide at a price of 2,80,000 rupees per vial of 50 ml. And NATCO, a Hyderabad-based Indian company, has applied for compulsory license, infringing the patent right of the original patent holder, Bayer AG. And now they are selling it at for just 8,800 rupees. The price differential between the two drugs being manufactured under the patent and being manufactured under the compulsory license reveals how much is the worth of the patents. There are seven kinds of intellectual properties. First of them is copyright. Another is patent, trademark, industrial designs, new plant varieties, integrated circuits, undisclosed information, geographical indications, etc. Now, since we are confined to the discussions relevant for scholars of various universities, including medical and health science universities, and therefore, I think we would like to focus on copyright, patents, and designs, which are relevant for persons of medical profession, as well as they are relevant for people working in various universities. It would not be out of place to mention that the way universities are being ranked worldwide by QS or Times Higher Education ranking, they also consider 8 major criteria. One of them is the publications, and another is the number of patents being applied and being granted to the scholars of university. And therefore, patents are crucial for university rankings also. And at the outset, I would also like to mention that very often researchers and scholars, they publish their findings through research papers. And once any innovation is published, then it comes in the public domain. And thereafter, patent cannot be applied. There are 3 criteria for grant of patent. First is novelty, nayapan hona chahiye. And once finding is published in any journal or any book or anywhere on the website, it is published, then it comes in the public domain, and it doesn't fall in the category of novelty. And therefore, every scholar should take this precaution that if he innovates something or there is some novelty in his or her findings, then instead of publishing or bringing it in the public domain, first of all, he or she should apply for online patent. And then after filing the patent or after submission of the patent application, he or she should publish it. So then his right to get a patent or copyright on that revelation or that finding or innovation should not be hampered. So first thing, I think every scholar who is present here should bear in mind that instead of publishing or even disclosing his innovation or her innovation anywhere on the website or in any publication, first he or she should apply for the intellectual property right, for the IPR. Maybe in case of copyright, he has to apply for copyright. In case of any other innovation, he will have to apply or she will have to apply for patent. And in case of any design, he will have to file for industrial design under the design registration. Because various surgeons and they also can modify various equipments being used or apparatus being used for surgery or for various biomedical equipments also, there can be some variations in design, or there can be a fresh or de novo category of biomedical equipment. Then in that case, one should apply for design registration. There may be underlying patents also. In normal cases, wherever any new computer software is developed, in that case, copyright is granted. But when it is embedded in the hardware, then one can apply for patent. Therefore, one should keep in mind that before disclosing the innovation, either in the form of publication or anywhere in digital form, one should apply for the IPR. That is number one thing. Another important aspect which I would like to mention is that these days a new branch of pharmacognosy is also developing. For example, when in South America, a lizard was found to be having a miraculous saliva, and now through DNA recombinant technology, that saliva is being created in laboratory synthesis, and Byetta is the type 2 diabetes drug. So these days, even various microorganisms are also being studied, and kind of enzymes they are producing, those enzymes are also being synthesized through DNA recombinant technology, and therefore patents are being applied on products of animal origin. Even nowadays, new plant varieties or genetically modified organisms are also being patented. For example, the fish that survives in the icy oceans or under frost, its gene which gives resistance against ice has been transplanted into tomato, and now frost-resistant tomato have been created. Now, when one gene is transplanted to another organism, a new plant variety or new genetically modified organism is created, and that also becomes patentable. So naturally occurring species are not patentable. So no herb, no plant, or no animal can be patented. But when one gene giving some special attribute to a particular plant or animal is transplanted to another plant or animal, and if a new plant variety or genetically modified variety is created, then that becomes patentable. And therefore, nowadays, the domain of the patent is very wide. The purpose of holding this seminar by the Pacific Medical University and Pacific Academy of Higher Education and Research University is to familiarize the scholars of these twin universities as well as others who have joined this program, to enable them to file patent application themselves online. So I think the hands-on exercise that would be given towards the end of this webinar would be enabling all the participants that they can file suo motu their patent application. This is number one. At the outset, I would also like to mention that many times, many scholars normally think that patent is a very complicated rocket science. As I normally say that there are 124 patents on tea kettle. So any variation or any novelty which you can add into any existing product can also be patented. That is number one. Even there are two kinds of patents. One is a product patent and another is process patent. Sometimes the innovations may not relate to a de novo kind of product. Then in that case, if you have developed some new process, then processes can also be patented. Even sometimes derivatives can also be patented. For example, the ciprofloxacin was invented by Bayer AG. And Ranbaxy company, they developed binding agents through which sustained release can be managed. That is new drug delivery method. They obtained a patent for that. And then Bayer AG purchased that patent for new drug delivery mechanism. And therefore, one should keep his or her senses open, and wherever one can apply intellectual property registration, one should try for that. Here, I would also like to mention, because mostly I think the registered delegates are from medical science as well as other scientific domains. So I would like to mention this commercial information also. That Chinese scholars apply almost 15 lakh patents every year. This is around 43% of patent applications being filed worldwide. While Indian scholars apply for nearly 50,000 patent applications every year. Difference is very wide. And therefore, China has almost 28.4% share in world manufacturing. India has only 3% share in world manufacturing. And therefore, creation of intellectual property and registration of intellectual property rights in the form of copyright patents also determines the fortunes of a nation and prosperity of a country. So I think there should not be any such mind block. And I invite all the delegates who are present here that whenever they are innovating anything, it may be related to a product, it may be just a mere process, or even sometimes it may be data compilation. Say, for example, an endocrinologist, he can simply ask the patients to maintain a diet chart and take the blood sugar levels. And then the whole of this case history of different patients can also be applied for copyright. And even surgeons may be using various ordinary tongs and various other knives and other apparatus, simple apparatus. And if they feel that if any small modification can be applied in its design, then I think that can also be patented. So Indian scholars should also keep this thing in their mind, that any kind of novelty which for which they have taken any inventive step, as I just lost the trail, there are three parameters which are necessary for getting a patent. First one is novelty. उसमें कुछ नयापन होना चाहिए. नई बात आप कुछ भी करते हैं तो you can get even distillery bottle design can also be patented if you modify for some convenience. So first thing is novelty. Another is inventive step. That is, you should have, that is, the applicant must have taken some step which has led to that invention. So therefore, discoveries are not patentable. If there is a natural phenomenon and you have just discovered it, it is not patentable. But when there is novelty and you have taken some inventive step, then you can apply for that. And third is its industrial or economic application. So it should fit on three criteria. Another important thing which I would like to mention, that even if there is any flimsy innovation, one can apply for that. For example, Conagra is a company which has applied for a patent on wheat flour. Wheat flour we have been using since several millennia. But since it was not earlier patented and it was not existing as the prior art in the hard disk of the controllers of the patents, and that's why company could get a patent on that. So wherever we should do it. Even, however, the traditional knowledge cannot be patented. But in case of secondary metabolites, say when some active ingredient in some herb can be identified, how to isolate it from that, and what kind of solvent and what kind of stabilizer and what kind of emulsifiers be used to add or give a shelf life to it. And therefore, there are many such herbal products which can be used in therapeutics are being patented by isolating that active ingredient from that herb and then bringing it in a storage stable stage. And for example, in case of neem cannot be patented. neem का patent नहीं लिया जा सकता है, लेकिन जब Agrasitas Grace एक कंपनी है और उसने नीम में से एजाडिरेक्टिन केमिकल कंपाउंड को बाहर लिया, जो which has the antifungal, antibacterial and antiseptic property, और उस एजाडिरेक्टिन केमिकल को what solvent be used, what stabilizer be used, what emulsifier be used, so that it can be given a shelf life of 2 to 3 years, and it could get a patent on that. So in India, we have a lot of traditional knowledge about utility of various herbs. And if through solvent extraction or through subcritical extraction or supercritical extraction, the secondary metabolites can be extracted, and if any particular secondary metabolite can be identified, and if it can be brought in a storage stable stage, patents can be applied on that also. And the most important aspect is that how many patents you are commanding to your credit, and how many patents a university is commanding to its credit. So that is very important in university ranking as well as in creating the intellectual property. And through that intellectual property, one can go for intellectual property management. So if a university has created a lot of intellectual property, it can manage and it can earn wealth from that. Now, without taking much of the time, because now it is time to equip the participants how to apply for patent, because there are patent attorneys who would be delivering the talk on the process of applying for patent. But one thing we should bear in mind, that whenever any new innovation is there, one should not hesitate to apply for IPR registration. Even say in case of India, almost 60 to 70% of the patent applications have to be withdrawn because of the prior art search violation or any similar other thing. But it doesn't matter. At least one should apply whether he gets it or not. Another important thing is that among the intellectual property rights, geographical indications are also an important intellectual property. Say when we say Langda Aam, then it is a geographical indication of Banaras. When we say Kota Doria Sari, then it is a geographical indication of Kota. When we say Bikaner Bhujia, then it becomes a geographical indication of Bikaner. So there are many such geographical indications also. There had been battles on GI, generic indications and geographical indications. Say there is a multi-billion-dollar case of basmati rice. When one company applied for 3 genetically modified varieties of rice, basmati, taxmati, kasmati, and jasmati, which were based on the germplasm of the basmati. At that time, many Indian NGOs filed a case against that company that it is a geographical indication of Tarai region of Himalaya, and therefore the company cannot get a patent. Company claimed that it is a generic indication, that is fine aromatic rice, long grain fine aromatic rice is basmati. We from India pleaded that no, it is not a generic indication, it is a geographical indication. This kind of long grain fine aromatic rice was being cultivated in Tarai region of Himalaya only. The case was contested, and ultimately we could get some gazetteers of 18th century where some British officers had sent report to the British Foreign Office that in India, in the Tarai region of Himalaya, a special variety of rice is being cultivated, which is so and so long grain and fine aromatic rice. And therefore, this evidence could just repudiate the claim of that company that it is a generic indication. So actually, intellectual property has many facets. Therefore, we should keep in mind, even in case of India, there had been many leading cases related to evergreening of patent. A.P. Gupta sir has already mentioned that when a drug goes off the patent after 20 years, but normally companies holding the patent in the 19th year, they develop a derivative of it and get a new patent for another 20 years. So this is called evergreening of patent. In India, India is the only country among the 200 nations in the world which has stopped this evergreening of patent. Section 3D of Indian Patents Act says that incremental research is not patentable. There was a leading case of blood cancer drug. Imatinib was invented in 1994. Then its derivative was patented in 1998. So imatinib was having a patent of 94, and imatinib beta chloride, a derivative of imatinib, was having a patent of 1998. The drug was being sold by Novartis for 1,200 rupees per tablet. At that time, 3 Indian companies, Hetero, Cipla, and Ranbaxy, they started manufacturing by developing alternative process of synthesis of imatinib beta chloride. And they started selling it for 90 rupees per tablet. At that time, in 2004, Novartis company obtained a stay from Chennai High Court. So almost for 1 year, 24,000 blood cancer patients had to forego their treatment because they could not afford to take 3 to 4 pills a day at a price of 1,200 rupees. But one could afford a 90 rupee per tablet price. So after 1 year, the case was decided in favor of the Indian manufacturers. Later on, the company went to Intellectual Appellate Board and then to ultimately to the Supreme Court. And in the Supreme Court, it was held that original patent was of 1994. All the molecules which are invented before 1995, they can be manufactured through alternative process of synthesis, because before any molecule which was invented before 1995, only process patents were being granted by India. And therefore, these 3 companies were allowed to manufacture on the basis of this section 3D, that imatinib is the basic patent, and imatinib beta chloride is a derivative of it, and therefore incremental research cannot be patented. Even there was a series of demonstrations in more than 50 to 60 countries, even in the Switzerland itself, at Basel, where Novartis company has its headquarters. Swiss people have demonstrated that the company should withdraw this case from the Supreme Court of India. So I think there are many legal issues, issue of international law. Say, for example, the COVID drugs, for which India has moved a case in the World Trade Organization. And almost 120 countries have supported the case that COVID drugs should be brought off the patent. And the debate is going on. and the decision is yet to be taken. But ultimately, it is a very vexatious issue, and I'll not be taking much of your time in these global and economic issues. So now we should focus, and I hope that the scholars who are attending this workshop would certainly be applying for 3 to 4 patents or copyrights in the time to come. Maybe for some process, or maybe for some equipment, or maybe for some drug, or maybe for repurposing of certain drug, or there are many such options which one should do. And even in case of others also, I think even for teaching pedagogies also, copyrights can be applied. So that can be done. Even in case of computer softwares, copyrights can be applied. So these days, many apps are being developed, many new softwares are being developed. So I convey my compliments to all the delegates, that every one of them commands enough number of intellectual property rights to his or her credit, and ultimately it is a gold mine if you have some meaningful innovations to your credit. So once again, and I also convey my thanks to Dr. Ritesh and Dr. Jayesh. They are the nodal officers for this workshop, and actually all the pains they have taken in designing this webinar. And I also convey my gratefulness to Professor A.P. Gupta, who has very willingly and sportingly, and Dr. Mangal, and Professor K.K. Dave, and all the stakeholders in the Pacific Group of universities, that they have extended their cooperation in the successful conduct of this webinar, planning and conduct of this webinar. So I convey my compliments to everybody. Thank you.
Thank you very much, sir, for guiding us various utilities of IPR in various segments, including pharma, plant varieties, life sciences, softwares, many more. Yeah, and you have a lot of knowledge. You are also part of WTO once, so you have great knowledge in that segment, and we are very fortunate to have you. And we need your continuous guidance and mentoring. And with this word, I'm thanking you, sir. Now it's a time we have a first session with Mr. Prateek. So we will start this session. Before starting, I'll introduce Mr. Prateek here, and he's a kind of entrepreneur. He was part of CPAM before, and he was a founder member of PNA IPR law firm, and he's currently working as a managing partner with PNA IPR law firm, and he's a qualified Indian patent agent. He has also completed law. He's a engineer, basic education, and he's also advocate, and he's practicing IPR laws since last 7 years. And he has a lot of experience. He was working with the government organization. He knows in and out about IPR patent filing. He has global clients, and many clients he's currently serving. So with his mentorship, today we will have one lecture on the how to file live patent application on with the Indian e-portal. Like we have system where you can file the patent online. And so over to you, Mr. Prateek, and now you can continue and you can share your screen. Are you able to hear me properly? Please unmute yourself. Yeah. Yeah. Prateek ji, we are not able to hear you. You are on mute, I think. Now try. Your voice, we are not able to hear.
He may not have unmuted himself.
Am I audible?
Yeah.
Ah, yes.
Very
Yeah.
much.
Sir, first of all, Thank you for giving me this kind opportunity. It is indeed my honor to be a part of this great seminar. I will, start with the process of filing patent application, how to file it, and what are the documents required to file it, and where you can file. So I will be focusing on each and every aspect of patent filing. So I'm sharing my screen. Just I hope you can see my screen, right?
Yes, sir. We can see your screen. You can start, I think.
Can you see my screen, please?
Yes, sir. We are able to see your screen. It is all visible. Sorry.
Yeah.
Sorry.
Okay.
Sorry.
Thank you.
Sorry.
Thank
Sorry.
you.
Sorry. You share your screen. It is not there. It is.
Okay. Just wait a minute.
Now, sir. Now we are able to see your screen.
All right. So thank you. Okay. So in India, patent application can be filed by two basically methods. That first is the electronic, and second is आप वहाँ patent office में जाके भी कर सकते हैं file. So अगर आप किसी पेटेंट अटॉर्नी को एंगेज करते हैं, इन दैट केस आपको इलेक्ट्रॉनिकली ही फाइल करना है, एंड इन अ केस वेयर इन यू थिंक दैट यू कैन फाइल योर पेटेंट एप्लीकेशन ऑन योर ओन, यू कैन अडॉप्ट बोथ दी स्टेप्स, लाइक you can file electronically as well, and you can go to the office and वहाँ पे जाके आप फाइल कर सकते हैं. Now to file the patent application, we are basically required to fill 5-6 forms. First is the form 1. Normally when we apply for something, जैसे कि हम किसी भी गवर्नमेंट ऑफिस में करते हैं, जाते हैं, तो हमको कुछ फॉर्म्स फिल करने होते हैं. तो सिमिलरली इज विद द इंडियन IPR this Japan laws. So for filing the patent application, first form is the form 1, so which is the application for a grant of patent. Second is form 2, जहाँ पे आपको पूरी स्पेसिफिकेशन ड्राफ्ट करके इस फॉर्म के संग आपको अटैच करनी होती है, एंड फिर आपको फाइल करना होता है. एक फॉर्म 3 फाइल होता है, एक फॉर्म 5 फाइल होता है, और अगर आप किसी अटॉर्नी को एंगेज करते हैं उसमें एक फॉर्म 26 फाइल होता है. तो उसमें आपको स्टाम्प आपको उसमें लगाने होते हैं. फिर तो अगर आप खुद फाइल कर रहे हैं तो फॉर्म 26 से आप ये स्टाम्प की इसमें बिल्कुल भी इसमें वो नहीं, इसमें रिक्वायरमेंट नहीं है. So the second question comes to what is the government fee for filing the patent application. Recently, the government of India has reduced the fee for filing the patent application for universities. Previously, the government fee for filing the patent application for universities was in line with the large entities. यानी जो fee एक large entity की होती थी, वही fees एक university को pay करनी होती थी. So thereafter, considering from the last 4-5 years, we have seen that the n number of patents applications have been filed only by the universities. So the government came up with the idea that why not to basically substantially reduce the government fee for filing the patent application. So the government then reduced the fee to 1600 only. Now the university can apply for patent by paying just only 1600 rupees. So this is the major booster for the universities now. Now we have seen from last 2-3 months that there is a substantial increase in the filing of these IP applications. तो पेटेंट एप्लीकेशन फाइल करने के लिए जो यूनिवर्सिटी या फिर जो आप स्कॉलर्स हैं वो खुद फाइल करते हैं, या फिर जो कोई स्टार्टअप है उनके लिए 1600 फी है, एंड अगर वो लार्ज एंटिटी में है तो उनकी फीस 8,000 रुपए फीस है उनकी. द नेक्स्ट स्टेप इज टू फाइल द रिक्वेस्ट फॉर एग्जामिनेशन. जैसा कि ऑनरेबल सर briefed about like the technical aspects of the IP applications. So जब हम किसी पेटेंट के लिए फाइल करते हैं तो ऑटोमेटिकली एग्जामिनेशन का रूल पेटेंट्स में नहीं है, एटलीस्ट इन इंडिया में वो रूल बिल्कुल भी नहीं है उसमें. कुछ कंट्रीज में है बट इंडिया में नहीं है. सो टू एग्जामिन दैट पेटेंट एप्लीकेशन वी नीड टू फाइल अ रिक्वेस्ट फॉर एग्जामिनेशन. So we are basically required to pay that fee, the government fee to the Indian patent office. So the government fee है for the university, for the startups, for natural persons, for small entities it is 4,000 rupees, and for large entity is 20K. So जब आप इसमें एग्जामिनेशन फाइल करते हैं, then the patent office takes up that patent application and then takes up for the request for the examination proceedings. So first of all, I will be focusing on the procedural aspects of patents, and then I will shift it to the live mode of how to file the patent application. So there are three steps after filing the patent application. First is the publication. जब आप पेटेंट एप्लीकेशन फाइल करते हैं, इट गेट्स पब्लिश्ड आफ्टर द एक्सपायरी ऑफ 18 months. So the importance of this in a publication is this, that applicants have all the rights of a granted patent from the date of your publication. So it after filing the patent application, it takes at least 18 to 20 months to get in a domain जिसमें हम देख सकते हैं कि हमने एप्लीकेशन फाइल की हुई है, और हम we can, and so that everyone can see that look that the Pacific University has filed a patent और उन्होंने ये इस चीज के लिए पेटेंट फाइल किया हुआ है. तो आपके जो राइट्स होते हैं वो उसी डेट से कैलकुलेट होते हैं. So now the question comes, if it is so important, then why, so can it be expedited? Yes, it can be expedited by filing a separate request. आप मतलब एप्लीकेशन फाइल करते टाइम भी आप उसकी रिक्वेस्ट कर सकते हैं फाइलर. सो रिक्वेस्ट फाइल करने के बाद जो प्रोसेस 18 months की है, इट कैन बी बेसिकली रिड्यूस टू 1-2 month. फिर आपकी 1-2 महीने के अंदर एप्लीकेशन हो जाती है, पब्लिश हो जाती है. सो द पब्लिक आफ्टर द पब्लिकेशन द एग्जामिनेशन प्रोसीडिंग्स गेट स्टार्टेड. अगर आपने रिक्वेस्ट फॉर एग्जामिनेशन फाइल किया है तो आपकी जो एप्लीकेशन है वो एग्जामिनेशन के लिए जाएगी. इन केस आपने फाइल नहीं किया है तो आपके पास 4 साल का टाइम होता है, कंसिडरिंग कि अगर आपने आज एप्लीकेशन फाइल की है, जैसे आपने कि आज 15 जनवरी 2022 को आपने एप्लीकेशन फाइल की है, तो टिल जनवरी 15 2026 तक आपको रिक्वेस्ट फॉर एग्जामिनेशन फाइल करना है. अगर आप फाइल नहीं करते हैं तो आपकी एप्लीकेशन विल ऑटोमेटिकली गेट अबेंडन. इसकी जो गवर्नमेंट फी है, as I told that the 4,000 rupees is the government fee for universities, and 20K is for the large entities. So after filing this request for examination, the patent office normally takes 1 year or 1.5 year to issue the examination report. And if you want to expedite the process of examination, then you can file a separate request for expedited examination. So in that case, the examination report can be issued in a period of 3-4 months. So after the examination, the patent office issues the examination report on the basis of the specification which you have filed. When I use the word specification, that means the technical specification. That is the whether the invention has the novelty or not, whether the invention has some sort of inventive step, whether your invention can be industrially used, and whether your invention falls under the ambit of the non-patentability criteria under section 3, or and other technical and non-technical objections which may arise while filing the application. So the applicant, after the issuance of the examination report, the applicant is required to comply with all the requirements within a period of 6 months, and the period of this the reply can be extended for another 3 months, or in अगर आप in extended आप इस extension के बाद इनकी अगर आप कर देते हैं, opportunity miss कर देते हैं अपना वो file करने की सारी requirements को comply करने की, तो आपकी application abandon हो सकती है. So, and this abandonment cannot be challenged in any court, at least in the IPAB. So after all the examinations and all these stuff, when and as and when you have complied with all the requirements, the patent office again examines your patent application, and either they may accept your patent application in one go, or they may also call us for a hearing. Now the hearing can be attended by both electronic means, and also you can go directly to the patent office and attend the hearings. Normally after the startup policy or the IPR policy, the government has mandated the patent agents to attend the hearing through video conferencing. So this is the importance, this is the important step which the government took to substantially ease down the procedural requirements of the IP applications. So if you have complied with all the requirements, the government issues the patent certificate like this, and the term of protection in India is 20 years, and the आपको फिर उस पर उसमें annuity pay करना होता है, which starts from 3rd year. So these are the procedural aspects of filing the patent application. Now I will be going to the e-filing portal. I hope you can see the website, right?
Yes, sir. We can see all the
Thank you.
like, browser.
Yeah. Thank you. So patent agents को और या अगर आप खुद एप्लीकेंट एज एन एप्लीकेंट फाइल करना चाहते हैं तो एक डिजिटल सिग्नेचर आपको सो आपको उसमें सर्टिफिकेट एक बनवाना होता है, सो दैट यू कैन साइन योर पेटेंट एप्लीकेशन ऑन योर ओन, और जो हमारी तरह रजिस्टर्ड एजेंट्स हैं वो उसको कर सकते हैं. तो ये एक इंटरफेस है गवर्नमेंट का. यहाँ पे आप सब कुछ कर सकते हैं, स्टार्टिंग फ्रॉम फाइलिंग और पेटेंट एप्लीकेशन एंड एंडिंग टू आप उसमें एनईटी भी कर सकते हैं, एनीथिंग यू वांट in this IP aspect. So this is a quick form filing tab wherein a new application, ये new application पर अगर आप जाएंगे तो एक इस टाइप का टैब है ना बन के आता है. नाउ एक टाइप ऑफ एप्लीकेशन पे जैसे क्लिक करते हैं आप, तो उसमें टाइप्स ऑफ एप्लीकेशन आप कर सकते हैं, सिलेक्ट कर सकते हैं. कन्वेंशन एप्लीकेशन है. तो हमारा जो केस है वो नॉर्मली इंडिया में हम ऑर्डिनरी एप्लीकेशन करते हैं, फाइल करते हैं. सो ऑर्डिनरी एप्लीकेशन भी 2 टाइप की एप्लीकेशंस होती हैं, प्रोविजनल और कंप्लीट. सो द बेसिक डिफरेंस ऑफ बिटवीन दिस प्रोविजनल एंड कंप्लीट इज that if your invention is not complete, or if you think that you need time to check whether your invention is patentable or not, so just to freeze your idea and to freeze the priority date, you can file the provisional application, and within a period of 12 months you can then file the complete specification. Or if you think that if your invention is complete, and you think that no, like my invention has some sort of novelty or inventive step, then you can directly file the complete specification. So considering कि हमारी invention अभी सारी complete है, so we are focusing on the complete specification only. So after selecting the tab of complete, we are basically required to fill these details, minor and details. फॉर इंस्टेंस कि मेरी स्पेसिफिकेशन में 14 पेजेस हैं and the number of claims are let's say 10 and the number of pages of the claim is 1 and the abstract yes 1 drawings हमारी let's say 8 हमारे पेजेस हैं और पेजेस भी 8 है हमारे. So these are the minor details which you are required to fill. Now this next step is to fill the title of invention. So what I have basically done is I have it's taking so much of time. Yeah, so इसमें आपको टाइटल ऑफ इन्वेंशन फिल करना होता है. हर इन्वेंशन का एक फॉर्मेट होता है, उसमें आपको टाइटल फिल करना होता है. टाइटल आपको ना बना के करना होता है which should be consistent with the with your invention and with in consistent with your claims which you have filed. So let's say the title of my invention is that a method of displaying टी ऑफ मीनू. सो ये मेरा एक नॉर्मल मैंने एक एग्जांपल लेके दिया है. सो टाइटल ऑफ इन्वेंशन आपको फिल करना होता है इसमें. एंड आफ्टर दिस यू आर रिक्वायर्ड टू फिल द एड्रेस फॉर सर्विस इन इंडिया. सो द एड्रेस फॉर सर्विस इन इंडिया इज समथिंग जहां से पेटेंट ऑफिस कम्युनिकेट करेगा आपसे. लेट्स से कि अगर आप खुद फाइल करते हैं पेटेंट एप्लीकेशन तो यहाँ पे आप खुद अपनी सारी डिटेल्स कर सकते हैं, जैसे कि आप अपना नाम, आपका एड्रेस क्या है, आपका फोन नंबर क्या है, आपकी ईमेल आईडी क्या है. यू कैन फिल ऑल दीज डिटेल्स. बट जब आप किसी एजेंट के थ्रू करवाते हैं फाइल तो यहाँ पे एजेंट की बहुत सारी डिटेल्स आती हैं. सो कंसिडरिंग कि आप किसी एजेंट से करवा रहे हैं तो एक जिसमें लेट्स से प्रतीक का नाम आ जाएगा एंड देन माय फर्म्स नेम एंड देन माय एड्रेस एंड देन माय फोन नंबर, समथिंग लाइक दैट. तो फिर उसके बाद आपको आपकी स्टेट चूज करनी होती है कि किस स्टेट से हो. अब इस केस में जो स्टेट चूज होगी वो होगी जो एड्रेस फॉर सर्विस के केस में है. सो माय स्टेट इज एमपी. सो नाउ फोन नंबर इसमें आपको आपका करना होता है, डालना होता है 901554008. यहाँ पे आपको ईमेल आईडी आपका डालना होता है pratik@pnaip.com. यहाँ पे आप अपनी ऑल्टरनेट ईमेल भी कर सकते हैं, डाल सकते हैं. सो द नेक्स्ट थिंग इज आपको फिर इसमें आपकी स्पेसिफिकेशन के बारे में थोड़ा मेंशन करना होता है, जैसे कि आपका एब्स्ट्रैक्ट क्या है. सो एनीथिंग व्हिच कैन बी एब्स्ट्रैक्ट. आपकी स्पेसिफिकेशन क्या है, आपको आपकी स्पेसिफिकेशन के बारे में मेंशन करना होता है. क्लेम्स आप एज इट इज कॉपी करके इसमें कर सकते हैं, इंसर्ट कर सकते हैं. तो ये सब इंफॉर्मेशन ऐड करने के बाद यू आर रिक्वायर्ड टू incorporate information about the applicant, okay, the like who is applying for it. So आप अगर एंटिटी हैं तो आपको ये मेल, फीमेल और अदर का ऑप्शन फिल करने की इसमें कुछ नहीं रिक्वायरमेंट नहीं है. इन केस अगर आप नेचुरल पर्सन है तो उस केस में आपको मेल, फीमेल और अपने बारे में आपको बताना पड़ेगा. सो कंसिडरिंग कि हम एक नेचुरल पर्सन या किसी स्टार्टअप के नाम से हम एप्लीकेशन कर रहे हैं फाइल, या नेचुरल पर्सन के नाम से एप्लीकेशन फाइल कर रहे हैं, तो हम फिर उसका नाम मेंशन कर देते हैं यहाँ पे प्रतीक. उसकी नेशनैलिटी के बारे में मेंशन करना होता है, उसका एड्रेस आता है और जो जो उसमें रिक्वायर्ड इंफॉर्मेशन है वो आपको फिल करनी होती है. और जो उसमें एप्लीकेंट की जो स्टेट है वो उसमें आती है. सो व्हाई दिस स्टेट इज इम्पोर्टेंट? स्टेट की इम्पोर्टेंस एक्चुअली ये है कि इंडिया में 4 पेटेंट ऑफिस हैं जो कि आपकी लोकेशन के हिसाब से आपकी जुरिडिक्शन सिलेक्ट करते हैं। जैसे कि अगर आप साउथ पार्ट, इंडिया के साउथ पार्ट में अगर आप करते रहते हैं तो चेन्नई विल बी और दी ऑफिस रहेगा, वो आईपी ऑफिस रहेगा आपका। अगर आप राजस्थान में रहते हैं तो आपको नॉर्थन पार्ट में जाके आप खुद दिल्ली में जाके पेटेंट ऑफिस में जाके आपको एप्लीकेशन फाइल करनी होगी। अगर आप वेस्टर्न पार्ट में रहते हैं तो आपको बॉम्बे पेटेंट ऑफिस में जाके एप्लीकेशन फाइल करनी होगी। अगर आप ईस्टर्न पार्ट में रहते हैं तो आपको कोलकाता पेटेंट ऑफिस में जाके एप्लीकेशन फाइल करनी होगी। सो ये सब इंफॉर्मेशन ऐड करने के बाद आपको ये ऐड करना है। एंड नाउ यू आर रिक्वायर्ड टू फिल द इंफॉर्मेशन अबाउट द इन्वेंटर्स। अब अगर इन्वेंटर अगर सेम है, अगर प्रतीक ही एप्लीकेंट है एंड प्रतीक ही इन्वेंटर है, so in that case you can select this and it will automatically select the inventors. Now in a case if the inventor is not same as the applicant, तो फिर आपको inventors को separately सारी information fill करनी होगी वो inventor के बारे में। Now the best part of the inventor is that any entity cannot be the inventor. सिर्फ natural person ही inventor हो सकता है। सो आपको यहाँ पे इन्वेंटर ऐड करोगे तो उसकी आपको उसकी कैटेगरी बतानी होगी, आपको क्या नाम है, उसका नाम बताना होगा, एड्रेस बताना होगा, उसकी नेशनैलिटी बतानी होगी एंड फोन नंबर्स एक्सेट्रा, ये सारी इंफॉर्मेशन फिल करनी होगी। एंड आफ्टर डूइंग ऑल सच स्टफ्स यू आर बेसिकली रिक्वायर्ड टू सिलेक्ट ऑल दिस। अगर आप प्रोविजनल फाइल कर रहे हैं तो प्रोविजनल के बारे में आपको मेंशन करना होगा। एंड इफ यू आर फाइलिंग द कंप्लीट, क्योंकि सारा प्रोसेस ऑनलाइन हो गया है तो वो ऑटोमेटिकली आपको ये सिलेक्ट करके देता है। बट जस्ट एक बार जब हम एप्लीकेशन फाइल करते हैं तो एक बार ये चेक कर लेना चाहिए हमको कि इफ इट इज फाइन और नॉट। तो आफ्टर सिलेक्टिंग ऑल दीज इंफॉर्मेशन आप सिलेक्ट कर सकते हैं कि आपको एक्सपेडाइट करनी है प्रोसेस। फॉर इंस्टेंस के अगर आपको पब्लिकेशन एक्सपेडाइट करना है तो फॉर्म 9 पे कर सकते हैं, सिलेक्ट कर सकते हैं। अगर आपको एग्जामिनेशन संघ में फाइल करनी है तो एक्सपेडाइट कर तो आप उसको संघ में सिलेक्ट करके आप उसको फाइल कर सकते हैं। सो आफ्टर ऑल ये सब स्टेप्स करने के बाद आप जैसे आई एग्री पे क्लिक करते हैं तो आपका फॉर्म ऐसे सेव हो जाता है। क्लेम इज मैंडेटरी, ओके। आपका ये फॉर्म सेव हो गया है। अब जब आपका फॉर्म सेव हो गया है उसके बाद आपको फॉर्म हिस्ट्री पर जाना है। आफ्टर गोइंग टू द फॉर्म हिस्ट्री, ड्राफ्टेड फॉर्म्स पे अगर आप जाएंगे तो यहाँ पे आपकी ऑटोमेटिकली फीस कैलकुलेट होकर हो जाएगी। सिंस आई एम अ नेचुरल पर्सन तो मेरी जो फी है वो 1600 है। अगर मैं यूनिवर्सिटी भी होता तो भी 1600 आती, मैं अगर स्टार्टअप होता तो भी 1600 आती, और अगर मैं स्मॉल एंटिटी होता, अगर कोई एमएसएमई होता तो भी 1600 रुपये आती। बट अगर मैं लार्ज एंटिटी होता, फॉर इंस्टेंस कि अगर मैं कोई कंपनी हूँ जिसका टर्नओवर which has crossed to approximately 100 crores, या मतलब मैं एक ऐसी कंपनी हूँ जिसका एक कंटिन्यूअस काफी 5-6 साल से अच्छा प्रॉफिटेबल वो टर्नओवर आ रहा है, तो मेरी जो गवर्नमेंट फी है वो 8000 रुपये ऑटोमेटिकली यहाँ पे सिलेक्ट होके आ जाती। So after selecting all this, you are basically required to upload all the forms which you have prepared for filing the patent application. So first of all, I will show you the forms. So जैसे हम फॉर्म 1 के बारे में बात कर रहे थे, तो जो फॉर्म 1 है कुछ इस टाइप का फॉर्म होता है। तो फॉर्म्स होता है, उसमें आपको बेसिकली सिलेक्ट करना होता है कि एप्लीकेशन ये आपकी सिंपल ऑर्डिनरी एप्लीकेशन है या कन्वेंशन एप्लीकेशन है या आप इंटरनेशनल एप्लीकेशन फाइल कर रहे हैं, तो आपको सिलेक्ट करना होता है। कंसिडरिंग कि हमारा ऑर्डिनरी एप्लीकेशन है तो हम उस पर सिलेक्ट कर रहे हैं। यहाँ पे एप्लीकेंट की बहुत ही डिटेल्स आती हैं। अब चूंकि ये जो एप्लीकेंट है ये एक स्टार्टअप है, तो इसकी जो नेशनैलिटी है वो इंडियन इंडियन तो है ही, ऑब्वियस बात है कि वो इंडियन है, बट उसका एक स्टेटस है, उसका एक लीगल स्टेटस है। तो हम नॉर्मली जब आप एप्लीकेशन किसी एंटिटी के नाम से फाइल करते हैं तो उसकी लीगल स्टेटस वो करते मेंशन करते हैं, दैट इज जैसे एक स्टार्टअप है ये, सो एन इंडियन स्टार्टअप बेसिकली रिकॉग्नाइज्ड बाय द डिपार्टमेंट ऑफ क्या होता है, प्रमोशन ऑफ इंडस्ट्री एंड इंटरनल ट्रेड, डीपीआईटी, गवर्नमेंट ऑफ इंडिया। अब वो किस कंट्री में है वो, तो वो इंडिया में फिर आएगा उसका, और उसका एड्रेस क्या है, तो इसमें आप अपना एड्रेस, वो आपको एप्लीकेंट का एड्रेस मेंशन करना होता है। Now, after filling the applicant details, you are required to select the category of applicant. कि applicant किस category में करता है, fall करता है। अगर मैं प्रतीक के नाम से application file कर रहा होता तो ये natural पर्सन पे वो करता, क्लिक मैं यहाँ पे वो करता, टिक है ना करता। अगर मैं कोई MSME, मेरे पे कोई सर्टिफिकेट होता तो मैं स्मॉल एंटिटी पे सिलेक्ट करता। इफ अगर मेरे पे कोई स्टार्टअप है, कंसिडरिंग ये जो फॉर्म्स है वो स्टार्टअप के नाम से है, तो मैं स्टार्टअप पे क्लिक करूंगा। अदरवाइज अगर मैं लार्ज एंटिटी होता तो मैं अदर्स पे क्लिक करता। देन उसके बाद इन्वेंटर्स के बारे में मेंशन इसमें करना होता है हमको। जैसे कि अगर आप देखेंगे कि ये जो एप्लीकेंट है वो अलग है, एप्लीकेंट है वो एंटिटी है, और जो इन्वेंटर्स है वो अलग है। तो इन्वेंटर्स के बारे में हमको मेंशन करना होता है कि लाइक हु, व्हाट इज द नेम ऑफ द एप्लीकेंट, व्हाट इज द नेशनैलिटी ऑफ द इन्वेंटर, सॉरी, एंड किस कंट्री में मतलब वो रहते हैं, व्हाट इज द एड्रेस ऑफ दैट इन्वेंटर। सो आफ्टर फिलिंग ऑल दिस डिटेल्स, आपको टाइटल मेंशन करना होता है। आप एक जो आपकी इन्वेंशन का स्पेसिफिकेशन का टाइटल है, आप वो मेंशन करते हैं। फिर आप किसके थ्रू फाइल करवा रहे हैं, किसी एजेंट के थ्रू करवा रहे हैं, तो उस एजेंट की डिटेल्स आती हैं, उनका नाम आता है, उनका फोन नंबर, उनकी फर्म का नाम और उनकी ईमेल आईडी आती है। अगर आप खुद के नाम से भी एप्लीकेशन फाइल करते हैं तो जहां से पेरेंट ऑफिस कम्युनिकेट कर सकता है उसके बारे में आपको इन्फॉर्मेशन मेंशन करनी है। अगर मैं पेटेंट एजेंट अगर हूं चाहे नहीं हूं, अगर मैं खुद के नाम से पेटेंट एप्लीकेशन फाइल कर रहा हूं तब भी यहाँ पे मेरा ही इसमें नाम आएगा। Next, these are the details for the international application. अगर आप इंटरनेशनल किसी और कंट्री से फाइल करते हुए इंडिया में आ रहे हैं तब आपको ये इन्फॉर्मेशन फिल करनी होती है। तो ये सारी इन्फॉर्मेशन फिल करने के बाद अब ये जो यहाँ पे जो नाम यहाँ पे लिखा हुआ है क्या बोलते, declaration by the inventor. So in this declaration by the inventor, that means कि अगर आपका एप्लीकेंट और इन्वेंटर अलग है, जैसे कि एप्लीकेंट इज इनोवेंटिव सॉल्यूशंस एंड, और जो इन्वेंटर्स हैं वो मनप्रीत सिंह सेठी हैं और कशिश वो हैं। अब यूएस में या कंट्रीज जो कि जैसे इंडिया है, यूरोप है, इनमें क्या है, इन्वेंटर का फर्स्ट राइट होता है, राइट। इन्वेंटर इज द फर्स्ट एप्लीकेंट ऑफ द इन्वेंशन। तो अब इस केस में इन्वेंटर अलग है और एप्लीकेंट अलग है, यानी एप्लीकेंट तो वही है ना जिस जो एप्लीकेशन कर रहा है, फाइल लेना कर रहा है। तो हमको ये शो करना होता है कि ये जो इन्वेंटर्स है, इन इन्वेंटर्स ने अपनी इन्वेंशन के जो राइट्स हैं वो एप्लीकेंट को असाइन कर दिए हैं, ट्रांसफर कर दिए हैं। सो इन दिस केस अगर आप इसमें इन्वेंटर्स के साइन करवा मतलब लेते हैं, जैसे कि यहाँ पे डेट एंड साइन यहाँ पे लिखा हुआ है, यहाँ पे अपने इन्वेंटर का साइन करा लिया और सेकंड वाले केस में भी करवा लिया है। सो दैट मींस कि दीज इन्वेंटर्स Mr. Manpreet Singh Sethi and Kashish Kapish have transferred their rights to the applicant. So now the applicant can file the patent application. So आफ्टर ऑल दीज आपको फिल करना होता है कि आप ये सारी इसमें चीजें आपको टैब आपको करने सिलेक्ट करने होते हैं कि इन्वेंशन का टाइप क्या है, कंप्लीट है कि प्रोविजनल है। अगर कोई इसमें ट्रू एंड फर्स्ट इन्वेंटर आप है कि नहीं है, आप असाइनी है तो आपको सिलेक्ट करना है। अगर आप किसी इंटरनेशनल एप्लीकेशन से प्रायोरिटी क्लेम करके इंडिया में आ रहे हैं तो उसके लिए आपको अलग फिर वो करना होता है, सिलेक्ट करना होता है। तो ये सारी इंफॉर्मेशन सिलेक्ट करने के बाद आपको फीस के बारे में मेंशन करना होता है। फीस इसमें जो कैलकुलेट होती है इलेक्ट्रॉनिकली, अगर आप फॉर्म में इसमें टैब में करेंगे तो वो ऑटोमेटिकली सिलेक्ट होके आ जाती है। बट वेयर इज दैट फॉर्म, हाँ, बट फॉर्म्स में भी आपको सारी चीजें मेंशन करके देनी होती है कि कंप्लीट स्पेसिफिकेशन में आपके पेजेस कितने हैं, आपके क्लेम्स कितने हैं, आपका एब्स्ट्रैक्ट कितने पेज का है, ड्राइंग्स कितनी है, एंड उसके बाद आपको फीस मेंशन करनी होती है कि दैट द फी ऑफ INR 1600 इज सबमिटेड ऑनलाइन थ्रू द इलेक्ट्रॉनिक पोर्टल। तो आपको ये सब चीजें मेंशन करके आज जिस दिन आप एप्लीकेशन फाइल कर रहे हैं वो डेट आपको मेंशन करनी होती है। अगर आप किसी एजेंट के थ्रू करवा रहे हैं तो एजेंट के साइन होते हैं, अगर आप एज एन एप्लीकेंट खुद फाइल कर रहे हैं तो यहाँ पे आपके साइन होते हैं इसमें, और फिर लास्ट में मेंशन करना होता है कि किस ऑफिस में आप फाइल कर रहे हो। अब ये जो एप्लीकेंट है ही बिलोंग्स टू पंजाब आई गेस, या तो इसका जो ऑफिस रहेगा वो ये रहेगा, जो दिल्ली पेटेंट ऑफिस रहेगा। So this is the basic form 1 which the applicant is required to fill. So the next important form is the form 2, which is the complete specification. अब जो complete specification है मैं उसके बारे में थोड़ा एक इंफॉर्मेशन दे देता हूँ। ये सारी आपको जैसे फॉर्म 2 है, यहाँ पे आपको इंफॉर्मेशन सारी मेंशन करनी होती है कि टाइटल ऑफ द इन्वेंशन क्या है, एप्लीकेंट कौन है, और ये जो प्रीएम्बल है आपका प्रीएम्बल, तो इस प्रीएम्बल के केस में नॉर्मली अगर आप प्रोविजनल फाइल करते हैं तो थोड़ा अलग प्रीएम्बल इसमें जाता है, और कंप्लीट फाइल करते हैं तो इस टाइप प्रीएम्बल इसमें जाता है। सो इस कंप्लीट स्पेसिफिकेशन में अभी चूंकि मैंने ड्राफ्ट की हुई है तो मैं ज्यादा इसको अच्छे से बता सकता हूँ कि इसमें आपको फील्ड मेंशन करना होता है कि आपकी इन्वेंशन किस फील्ड से आपकी रिलेट करती है। आपको इन्वेंशन का बैकग्राउंड देना होता है कि अगर कोई प्रायर आर्ट जिसकी आपको नॉलेज है, जो आप सोचते हैं कि हमने इस प्रॉब्लम, जो एक प्रॉब्लम थी इस प्रायर आर्ट में, प्रायर आर्ट कुड बी एनीथिंग, इट कुड बी दी पेटेंट रिलेटेड सब्जेक्ट एप्लीकेशन, और दी नॉर्मल अगर किसी ने यूट्यूब पे वीडियो बना के भी अगर कर दिया है तो वो भी प्रायर आर्ट में कंसिडर हो सकता है। किसी ने कोई कागज लिख के अखबार वाले को छाप के अगर वो छापने को दे दिया है तो वो भी प्रायर आर्ट में कंसिडर होगा, क्योंकि उसकी नॉवेल्टी किल हो चुकी है। तो आपको ये सारी इंफॉर्मेशन जो है आपको इसके अंदर फिल करनी होती है बैकग्राउंड में, एंड देन यू आर रिक्वायर्ड टू स्टेट द ऑब्जेक्ट ऑफ इन्वेंशन। जो आपने प्रॉब्लम आइडेंटिफाई कर ली है, प्रॉब्लम बता दी है, देन यू आर रिक्वायर्ड टू फिल दैट व्हाट इज द एक्चुअल ऑब्जेक्टिव ऑफ योर इन्वेंशन। तो फिर ऑब्जेक्टिव फिल करने के बाद आपको समरी देनी होती है कि हाँ कि मेरी जो इन्वेंशन है इट इज समथिंग ऐसा 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 करके है, ये सब सारी चीजें बतानी होती है। फिर ड्राइंग्स के बारे में मेंशन करना होता है। फिर ड्राइंग्स के बाद आपको ब्रीफली बताना होता है कि ड्राइंग्स से कनेक्टेड कैसे है आपकी इन्वेंशन। आपकी जो इन्वेंशन है, उन जो आपने ड्राइंग सबमिट की है, इस कोई फीचर कैसे कोई काम कर रहा है, इफ कोई ए फीचर है तो वो बी से कनेक्टेड होके कैसे काम कर रहा है। तो एवरी माइन्यूट जितनी भी छोटी से छोटी इंफॉर्मेशन है वो आपको इसके अंदर आपको इंफॉर्मेशन फिल करके देनी होती है। सो आफ्टर गिविंग ऑल दिस इंफॉर्मेशन you are basically required to put the claims। आप एक्चुअली में क्या क्लेम करना चाहते हैं। आपकी जो इन्वेंशन है, ठीक है, आपने स्पेसिफिकेशन में जो आपको बताना था आपने बता दिया कि एक प्रायर आर्ट था, हम उस पर्टिकुलर प्रॉब्लम को सॉल्व कर रहे हैं, बट आप उस प्रॉब्लम से क्या क्लेम करना चाहते हो। व्हाट इज द एक्चुअल बाउंड्री ऑफ योर इन्वेंशन, व्हाट इज द स्कोप ऑफ योर इन्वेंशन। सो इन दैट केस आपको उस केस में आप बताना होता है कि हाँ ये एक चीज है, इसके फीचर्स ये हैं, और इस फीचर्स में जो नॉवल और इन्वेंटिव फीचर है वो हम ये चीज है, मतलब तो जो चीज क्लेम करते हैं वो वेरिएंट के बाद आता है। तो ये सारी इंफॉर्मेशन फिल करने के बाद आपको वो ड्राफ्ट करने के बाद आप इसमें इनकॉर्पोरेट करते हैं। अब चूंकि यहाँ पे दो टाइप के वो हैं क्लेम्स हैं, एक सिस्टम क्लेम है और एक मेथड क्लेम है। तो मेथड क्लेम मींस कि कोई प्रोसेस है, आप उस प्रोसेस को कर रहे हैं, क्लेम कर रहे हैं, तो उसके बारे में आपको इन्फॉर्मेशन देनी होती है कि आप उस प्रोसेस को कैसे यूज कर रहे हैं, आप कितना वोल्टेज, जैसे कि मैंने इस इन्वेंशन में लिखा है कि वोल्टेज कितना अप्लाई कर रहे हैं, हम क्या यूज कर रहे हैं, कौन सी टच स्क्रीन यूज कर रहे हैं, और हम क्या क्या कौन से इंटरफेसेस हैं वो यूज कर रहे हैं। तो ये सारी इंफॉर्मेशन ये सब करने के बाद, देने के बाद, आपका जो स्पेसिफिकेशन है वो रेडी हो जाता है। हाँ, एक लास्ट एक एब्स्ट्रैक्ट होता है, तो आपको ये एब्स्ट्रैक्ट, इसमें आप एब्स्ट्रैक्ट आपको करके देना होता है, लिख के मतलब देना होता है कि दैट जो एब्स्ट्रैक्ट है दैट विल बी प्रेजेंटेड इन ऑन योर फ्रंट पेज ऑफ स्पेसिफिकेशन। सबसे पहले अगर कोई चीज अगर देखता है तो आपको वो एब्स्ट्रैक्ट ही देखेगा। आपका एब्स्ट्रैक्ट इस टाइप से होना चाहिए कि एब्स्ट्रैक्ट पढ़ने के बाद उसको स्पेसिफिकेशन खोलने की जरूरत ही ना मतलब पड़े। So normally it is an art to incorporate all the information in the abstract so that no one should मतलब उसके बाद किसी और को जरूरत ही ना पड़े कि वो आपकी स्पेसिफिकेशन खोल के देखे कि आपकी इन्वेंशन क्या है। So this is all about the form 2. Next is the form 3. ये एक फॉर्म 3 इंफॉर्मेशन आपको ना देनी होती है। नॉर्मली जब इंटरनेशनल एप्लीकेशन जब हम फाइल करते हैं, सो हम एक तरीके से कंट्रोलर की हेल्प करते हैं। वी असिस्ट देम बाय फाइलिंग दिस फॉर्म 3, वेयरइन हम जितनी भी कंट्रीज में प्रोसिक्यूशन हो रहा है, जैसे कि मेरा यूएस में अगर मेरे किसी क्लाइंट ने एप्लीकेशन फाइल की है और वहां के ऑफिस सेक्शन में एप्लीकेशन अबेंडन हो गई है, so now it is the duty of the applicant to inform the controller within a period of 6 months, every 6 months through this form कि हाँ मेरी एप्लीकेशन वहां पे अबेंडन हो गई है। so अब ये इंफॉर्मेशन की इंपॉर्टेंस क्या है देने से कि अगर मैं कोई फीचर यहाँ इंडिया में ऐसा कोई फीचर है जो कि ग्रांट हो रहा है वहां पे अबेंडन हो गया है, so the patent office could look into the office section of the American office section and check कि वहां क्यों abandon हुई है, ये इंडिया में क्यों accept हो रही है, तो फिर उस चीज को मैच करने के। so it is a basically a job of the applicant to inform the applicant to inform the controller within a period of 6 months, every 6 months. so ये एक फॉर्म ऐसा है जो हम हर 6 महीने में इंटरनेशनल एप्लीकेशन के केस में फाइल करते हैं। The next important form is the form 5. अब एक हमने जैसे फॉर्म 1 में देखा था कि यहाँ पे इन्वेंटर्स जो है वो साइन करके दे रहे हैं कि दैट वी हैव ट्रांसफर्ड और असाइंड ऑल आवर राइट्स टू द एप्लीकेंट, दैट इज द इनोवेंटरी सॉल्यूशंस। Now in the case of form 5, the applicant is giving a declaration that I believe that these all inventors mentioned herein are true and first. यानी मैं एक तरीके से वो दे रहा हूँ, डेक्लेरेशन दे रहा हूँ कि हाँ मैं एप्लीकेशन फाइल जरूर कर रहा हूँ, बट किसी के राइट्स उसमें मैं मतलब उसमें कोई एक तरीके से अबॉलिश नहीं हो रहे हैं, और अबॉलिश के संग संग आई बिलीव कि ये जो इन्वेंटर्स है ट्रू एंड फर्स्ट है। कोई ऐसा मत किसी और के राइट्स को हम नहीं कर रहे हैं, उसमें इन्फ्रिंज नहीं कर रहे हैं। सो ये फॉर्म एक आपको सबमिट करना होता है। सो अपार्ट फ्रॉम दिस फॉर्म 5, अगर आप स्टार्टअप है तो आपको एक फॉर्म 28 देना होता है, जैसे कि इसमें ये एक फॉर्म 28 है, ये आपको देना होता है। अगर आप किसी एजेंट के थ्रू एप्लीकेशन फाइल करवाते हैं तो आपको एक पावर ऑफ अटॉर्नी देनी होती है, उसका भी मेरे पास टेम्पलेट है। तो 100 रुपए के स्टाम्प पेपर पे स्टाम्प ड्यूटी पे होती है इसमें, और एक तरीके का फॉर्म 26 हम देते हैं क्लाइंट जो हमारे एप्लीकेंट्स हैं उनको मतलब बना के देते हैं, जो कि वो साइन करके देते हैं। सो दिस गिव्स अस एन ऑथराइजेशन कि हम उनके बिहाफ पे एप्लीकेशन फाइल कर सकें। सो नाउ आफ्टर जब हमारे ये फॉर्म्स देख लिए तो हम वापस चलते हैं टू दी ई फाइलिंग पोर्टल। अब हम फॉर्म हिस्ट्री पे जाके एक बार मैं फिर से रिपीट करके बता देता हूँ आपको। ये ड्राफ्टेड फॉर्म्स पे जैसे आप इन्हें जाते हैं, लॉग आउट हो गया, हाँ। सो ड्राफ्टेड फॉर्म्स पे हम फिर से गए, इसको यहाँ से सिलेक्ट किया, और जैसे ही हम अपलोड पे क्लिक करते हैं तो ये जो फॉर्म्स यहाँ पे ने लिखे हुए हैं फॉर्म 1, तो फॉर्म 1 हमने जो किया है, सिलेक्ट किया है, बनाया है, उसको फिर हम यहाँ से सिलेक्ट करके चूज फाइल करके उसको अपलोड फिर उसको कर देते हैं। फिर ये सब जब फॉर्म हमारे सारे हो जाते हैं, सारे अपलोड हो जाते हैं, एंड आफ्टर द अपलोडिंग ऑफ ऑल दीज फॉर्म्स वी आर बेसिकली रिक्वायर्ड टू साइन दीज डॉक्यूमेंट्स। सॉरी, अब ये जो साइन करने का जो साइन जो करते हैं वो एक तरीके का पेन ड्राइव टाइप का आता है। नॉर्मली हमने देखा होगा जब हम ITR फाइल करते हैं तो हमको एक USB टाइप का एक वो मिलता है, जिसको हम शब्द DSC बोलते हैं, डिजिटल साइन हम उसमें बोलते हैं। तो उसी के थ्रू हम एप्लीकेशन कर सकते हैं, फाइल करते हैं, whether you are engaging the attorney or you are not engaging the attorney. In every case, you are required to sign the document, and the application can be signed by that USB thing only. And so after signing the document of payment पे जाके make पेमेंट सबमिशन पे जाके पेमेंट कर सकते हैं। यहाँ पे एक तरीके का टैब आ जाता है बना हुआ, वो सब चीजें कर लेते हैं, पेमेंट कर देते हैं, तो एक तरीके की फाइलिंग क्या बोलते हैं, रिसीट आपकी आती है। वो फाइलिंग रिसीट से आप शो कर सकते हैं कि हाँ हमने पेटेंट एप्लीकेशन फाइल करी है। अब जब हमने पेटेंट एप्लीकेशन फाइल हो गई है तो हमको चेक करना है कि हमने कौन कौन सी पेटेंट एप्लीकेशन फाइल करी है या कितनी फाइल करी है। तो हम पेमेंट हिस्ट्री पे जाके चेक कर सकते हैं कि हमने कहाँ कौन कौन सी पेटेंट एप्लीकेशन फाइल की है। चूंकि ये एजेंट मेरा लाइसेंस है तो आप ये देख रहे होंगे कि 15, 14, 13 ये इन दिन में मैंने एप्लीकेशन फाइल मैंने करी है। तो स्टार्टिंग फ्रॉम द फर्स्ट एप्लीकेशन एंड एंडिंग टू आज तक के एप्लीकेशंस की इंफॉर्मेशन सारी इसमें होती है। आप जब भी चाहें जो डॉक्यूमेंट्स आपने अपलोड किए हैं वहां से सिलेक्ट करके आप अपलोड कर सकते हैं, आप चेक कर सकते हैं। और आप आप ये चेक करना चाहते हैं कि आप इन केस अगर आप की जो फाइलिंग ऑफिशियल फाइलिंग जो आपकी बहुत ही रिसीट आती है वो खो गई है, तो आप डाउनलोड CBR पे जाके भी आप यहाँ से सिलेक्ट करके आप यहाँ से सर्टिफिकेट आ जाता है, वो रिसीट आ जाती है। तो इस टाइप की रिसीट आती है आपकी एप्लीकेशन की। एप्लीकेशन फाइल करने के बाद आपकी रिसीट इस टाइप की आती है जिसमें आपकी सारी डिटेल्स मेंशन होती हैं कि आपकी एप्लीकेशन नंबर क्या है, आपने कितना अमाउंट पे किया है, आपने कौन कौन से फॉर्म फाइल किए हैं। अब जैसे इस वाले केस में ये जो हमारे क्लाइंट है कि हर बार पब्लिकेशन जो है वो एप्लीकेशन के संग में ही करते हैं फाइल, तो उनकी जो एप्लीकेशन है विद इन अ पीरियड ऑफ 1 मंथ या 15-20 डेज में उनकी एप्लीकेशन गवर्नमेंट वेबसाइट पे शो हो जाती है। सो इससे जो एडवांटेज है वो ये है कि वो लोगों को बता सकते हैं दैट वी हैव अप्लाइड फॉर अ पेटेंट, या हमारा या ये हमारी इन्वेंशन है। सो विच हेल्प देम इन बेसिकली अप्रोचिंग द क्लाइंट्स, या वो चाहते हैं कि हम किसी को कमर्शियली ट्रांसफर करें। तो ये सारी चीजें इंपॉर्टेंस होती हैं अगर आपकी एप्लीकेशन गवर्नमेंट पे शो होने लगती है, गवर्नमेंट वेबसाइट पे शो होने लगती है। सो इसमें टाइटल भी शो होता है, आपने चूंकि ऑनलाइन पेमेंट किया है तो इसमें ऑनलाइन के बारे में बताता है कि ऑनलाइन बैंक ट्रांसफर किया है। So this is all about the patent filing and the procedure of filing the patent application. I hope it was very succinct and it was in a very simple terms that. So thank you. That's all about my filing thing.
So thank you very much, Mr. Prateek, and you have nicely covered the patent filing, e-patent filing. You have taken all the examples, how to fill forms, and some basic aspects also you have covered. I think it will be the great session, and our audience definitely they got a lot of things out of your training. And if I am requesting all the participants, if they have any query, they can write in chat box, or otherwise you can contact us anytime. We are we have shared our emails on where you have already received invitation from our emails. So this is the IPR cell we are heading. So this way it was a very nice lecture. The Prateek ji, thank you very much. And I'm waiting for some questions. If people have any questions, they can write in chat box. So right now I'm not getting any questions. So I think I think we can proceed for another session where I am going to take the patent drafting and critical nitty-gritties related to patentability. So thank you very much once again, sir, for joining us. And it was a great interaction with you. And we will have another session soon. So we will inform you time to time. Thank you, sir.
Ritesh,
Yes, sir.
if Prateek ji can throw some light in 3 to 4 minutes about copyright registration, because many of the faculty members, they may be having clinical observations and many other data. So they may also think of applying for copyright registration. If he is comfortable and he is having preparation, then in next 4 to 5 minutes we can use that time so that people would make up their mind on thinking to apply for a copyright also. Prateek ji, if you are comfortable.
So Prateek ji, are you able to hear us?
Yes, sir. Yeah.
Yeah, sir. So you can reply like you were.
Yes,
Are you
sir. Yeah. Yes, चूंकि अब जैसे चूंकि सर ने बताया था starting में that there are 7 to 8 types of IP. First is the patents, second is the copyright, and third is the trademarks, fourth is the industrial designs and the geographical indication. So the oldest and the first and the oldest form of IP is the copyright. When I use the word copyright, that means के मेरी कोई ऐसा आइडिया है, कोई टेंजिबल या इंटेंजिबल फॉर्म में जिसको कोई कॉपी नहीं कर सकता, या मेरे पास उसका कोई राइट है. सिर्फ एक कॉपीराइट ही एक ऐसा राइट है जो कि सबसे लॉन्गेस्ट मतलब ट्रेडमार्क तो हालांकि उसको वो लाइफ टाइम ही होता है, बट एक कॉपीराइट भी एक ऐसा राइट है जिसका टाइमलाइन जो है सबसे हाईएस्ट है. जैसे कि जो टर्म ऑफ प्रोटेक्शन पेटेंट्स है वो 20 इयर्स है, और जो टर्म ऑफ प्रोटेक्शन इन द इंडस्ट्रियल डिजाइन है इट इज फॉर द एक्सटेंडेड 10 to 15 इयर्स. कॉपीराइट में इज द लाइफ टाइम ऑफ एन ऑथर, and after the lifetime after the lifetime of an author 70 years. So that means अगर हम on an average अगर age देखें तो 70 to 80 years अगर लोगों की एज होती है, उसके बाद भी we have 70 years. So there is a protection of almost 140 to 150 years from the date of filing the copyright application. So the next question comes whether it is necessary to file the copyright application. Of course not. It is not that mandatory to file the copyright application. The moment you create something, it basically becomes your copyright. As you have seen, that patent is basically granted to the inventions, to the science related stuffs. Trademark is basically granted to your mark related stuffs. Geographical indication is something which basically defines a locality, and so the copyright is something if you have created something which is artistic in nature, and if it is basically you have आपने कोई किताब आपने इंफॉर्मेशन आपने करी, आपने लिखी है, कोई कंप्यूटर का प्रोग्राम आपने किया है, लिखा है, सो इन दैट केस वो कॉपीराइट में करेगा, फॉल करेगा. अगर आपने पेंटिंग बनाया है तो वो आर्टिस्टिक वर्क में करता है, आर्टिस्टिक वर्क में करता है, फॉल करता है. किताब लिखी है तो वो क्या बोलते हैं लिटरेरी वर्क में फॉल करता है. अगर आपने कोई जैसे कोई आपने कोई सॉन्ग आपने लिखा है तो वो सिनेमेटोग्राफिक में आपका वो करता है, फॉल करता है. नाउ हाउ टू फाइल इट.
है इसका हम ले Okay. Sir, I think Prateek, sir, I'm just calling him. Sir, I think there was some problem with Mr. Prateek's side. So maybe we can have we can start another session, or like you tell me how you want, or we can wait for 5 minutes. He's calling me. Just wait.
Acha, Dr. Ritesh, are you hearing me?
Sir, just hold for a minute. I am just
Okay, fine.
on the
fine.
call, sir.
You may have a connection with the
Sir, he is just joining, sir. He's just joining, sir.
Okay, fine.
I think there was some network issue. That is why he left.
Meanwhile, Dr. Ritesh, within a couple of minutes, you can also brief if any of the delegates in this webinar has interest. They can also appear in the exam for patent agent, and then they can become patent attorney, or they can develop this expertise that it is being conducted twice in a year, and what kind of a exam it is. Any science graduate or can apply. So I think within 2 minutes you can. So any 1 or 2 person may also think of let me introduce Dr. Ritesh is also a qualified patent attorney. He has also cleared the patent agents exam, so he also has very good expertise.
Yes, sir. I think we have Prateek, sir. He has joined already. So
Fine. Okay.
yeah.
Okay.
So Prateek ji, can you continue with your talk?
Yes, sir. Yeah.
Yeah.
So-
Please go ahead, sir.
Thank you. So to file the copyright application in India, आप उसको physically जाके भी file कर सकते हैं, and you can file electronically as well. So electronically file करने के बाद इसमें कोई ऐसा formal examination के नाम की चीज में, मतलब अगर आपने कोई चीज अगर आपने करीब बनाई है, जैसे पेटेंट्स में देयर इज सब्सटेंटिव एग्जामिनेशन. अगर आपने पेटेंट एप्लीकेशन फाइल की है तो वो हर एक चीज करते हैं स्टेप, वेदर इन्वेंशन इज इन्वेंटिव और नॉट. इन द केस ऑफ कॉपीराइट, अगर आप एप्लीकेशन फाइल करते हैं तो उससे फॉर्मली वो चेक करते हैं कि सारे आपने जितने भी वो डॉक्यूमेंट्स दिए हैं वो सही सेट है कि नहीं है. अगर वो सही सेट है, दैट मींस इट कैन बी ग्रांटेड विद इन अ पीरियड ऑफ 2-3 months. तो ये आपका फॉर्मल रजिस्ट्रेशन हो जाता है. इसमें ऐसा कोई खास प्रोसीजर नहीं है इसमें करने का. इट इज अ वेरी सिंपल प्रोसीजर. 2-3 महीने में आपको रजिस्ट्रेशन भी आ जाता है आपके पास. जिस दिन से आप एप्लीकेशन फाइल करते हैं, इट बिकम्स द प्रोटेक्शन हैज बीन एक्सटेंडेड. तो आपकी जो प्रोटेक्शन है, इट इज फॉर ऑलमोस्ट 140-150 years in India. So this is all about the copyright protection in India. ऐसा कोई खास प्रोसीजर नहीं है सर इसमें, बट ऐसा कोई सब्सटेंटिव प्रोसीजर नहीं है. सिर्फ आपको एप्लीकेशन फाइल करनी होती है, एंड इट कैन बी फाइल बोथ इलेक्ट्रॉनिकली और आप काउंटर पर जाके भी फाइल कर सकते हैं. थैंक यू.
So, sir, definitely thank you, Pratik ji. And I understand maybe the next time we can take one program where we can file one e-copyright filing the way we have to file with this government portal. So, it was a great pleasure talking to you, and thank you very much for your efforts. Sir, you want to say anything here, Bhagwati, sir?
No, that's okay. If he is comfortable, then I'll just be regarding design, because many of the surgeons from Pacific Medical College and Hospital, they may be modifying the normally jo used apparatus for surgery, maybe any including knife or tongs, etc. So for better efficacy in surgery, if they modify the design of any existing equipment or apparatus being used in the surgery, and if out of his or her experience he feels that this design can be improvised, so this modification in the design, and if it doesn't fall in the prior art, and if it is a new, so should they endeavor to apply for design registration? If we would clarify, then I think many of the people from surgery branch may be benefited.
Yes, sir. So, sir, thank you for this, for this question. Actually, I was about to, point out the uh, basically difference between patents and patent designs. So, in patents, we have a product and a process, and we get protection in the overall configuration of the product. And in the case of designs, the protection has been extended only to the shape and configuration of the article. So, if आपको protection इस केस में आप ग्रांट बिल्कुल भी नहीं होती है, जैसे कि पेटेंट में प्रोसेस भी मिलता है, प्रोडक्ट भी मिलता है। इस केस में डिजाइन के केस में फंक्शनैलिटी पे आपको प्रोटेक्शन नहीं होती है। अगर आपने कोई प्रोडक्ट बनाया है, जैसे कि आपने कोई सर्जिकल इक्विपमेंट बनाया है which was already known to the सबको known था वो, and you have merely improved some sort of the style of that article, then yes, you can endeavor, you can basically try to file the application, and yes, you can be granted the protection if it is new, right? If that article, if that shape is new, then of course yes, you can get the protection in India. So the protection in India is granted for the initially for the period of 10 years, and it can be extended up to 5 years. So starting from the date of filing, आपको आज की तारीख से एक्सटेंडेड जो प्रोटेक्शन है वो 15 इयर्स की आपको उसमें होती है। 15 साल के बाद आपको जो प्रोटेक्शन है वो आपकी नॉवेल्टी किल हो जाती है उसमें। यू डोंट हैव एनी राइट ओवर द प्रोटेक्शन। हाँ, so the question comes कि उसको फाइल करने के लिए प्रोसेस क्या है? टू फाइल दैट एप्लीकेशन सिमिलरली विद द, जैसा कि आपने और आईपीएस के बारे में देखा है कि एक ई फाइलिंग पोर्टल होता है, सिमिलरली इसमें भी एक ई फाइलिंग पोर्टल होता है, बट इसमें डिफरेंस ये है कि इसकी एप्लीकेशन से कोलकाता में फाइल होती है। सो कोलकाता में फाइल करने के लिए आपको ई फाइलिंग पहले एप्लीकेशन फाइल करनी होती है, एंड आफ्टर फाइलिंग दैट एप्लीकेशन आपको सारे हार्ड कॉपी डॉक्यूमेंट सबमिट करने होते हैं हार्ड कॉपी में। उसके बाद एक सब्सटेंटिव एग्जामिनेशन होता है, एंड आफ्टर द एग्जामिनेशन प्रोसीडिंग्स वो आपको सर्टिफिकेट इशू जाता है विद इन अ पीरियड ऑफ 7-8 months. So this is all about the industrial capital design. So if you want, I can have a separate session on the copyright and the other IPs as well, and how to calculate what are the technicalities being involved in this IPs.
So definitely, Pratik ji, next time we will have
Pratik
this
ji,
kind of thing.
Pratik ji, I am over encroaching upon your liberty, but many of our experts or surgeons, they also develop some new processes that instead of adopting standard process in surgery, which is prescribed in the surgery books, they invent some additional modification, or they develop new processes. So is it feasible to apply for a process patent when you have developed a new process for performing a surgery?
Sir, that is not patentable in India.
Fine.
The equipment per se can be patented, but the method of performing the surgery is not patentable in India. In India, at least in India. In some countries such as US, of course, you know, they have some separate laws. It can be granted in US, but not in India. Considering the situation here, the method of agriculture, method of performing the surgeries, and method of the computer program, these are not. इसके लिए पेटेंट इंडिया में नहीं होता है, ग्रांट नहीं होता है.
ठीक है, now you can proceed ahead as per your schedule.
Yes, sir.
Dr.
Thank
Dinesh.
you very much, sir. So Prateek sir, thank you very much again for taking this session, and we all are very thankful, and definitely next time we will have another topic. Other IPs are remaining, so we will take other IPs, and we will also see the other filings as well, and it is a continuous effort we have to do. So thank you very much, and now shall I start, sir, next session?
Yes, yes.
Yeah. So now I am just sharing my screen. We will have the one presentation, and after that we'll see some case studies on patent drafting. So I am just taking my screen sharing. So all are able to see my screen now. My screen is visible.
Visible, sir, visible.
Yeah. So once again, as a speaker, I am there today for this session. So I have drafted the one presentation, and where I will touch a lot of different aspect which comes practically whenever as a researcher we think of filing the patents here in India, and whatever resource we have. So so to start with, this is the most of the things somewhere are Bhagwati sir and Prateek ji has covered while saying a lot of things related to IP. But this is just to start with. These are the basic IP. It is we have law statute here in India, so we can find the different IP based on the kind of subject matter we have. So basic understanding we need to have, if you have certain subject matter related to, like sir was asking the same question, like if somebody is doing any improvement in surgery, what kind of patent they should look and what kind of IP they should select. So these are the basic questions inventor has in their minds, and they are not able to take certain decision. They go for general publication, and there they destroy everything, because once it is in prior art, so that way it is not possible to get the patents out of it. So to start with, some critical points or misconceptions before patent drafting we need to understand. So some points are other audience are all other speakers and leaders, they have taken care. But still, as a serious note, I am just taking all the points where I see the observation within the university, across the university, within the academic resources. They have normally a big concern. They want to file the journal, or they go for the journal publication, and then after they think of the patent filing. So Bhagwati sir has already elaborated. If you want to file a patent, you want to protect that idea, and if it is worth to protect that idea, that is also is very understood thing. Filing a patent, it is a some commercial activity you are looking for, and here you have to see there is a cost attached. And if you're filing here in India, you will get the protection here in India only. It is not a global protection. So that way, a lot of strategy you have to think, and what is the kind of commercialization you can do out of your invention. So first, if you want to file a patent, file a provisional patent specification, or the complete patent specification as per the your research work status. If you are comfortable with the full data, you can file the directly complete patent specification with the Indian Patent Office. Otherwise, you can go for the provisional filing where only abstract is okay, you can file your invention, and then in the second day or subsequently you can go for the general publication. So it is a just a initiative you have to take. So this is one message we want to take. Then like while opting a patent or like the copyright, so there are certain things in here in India, it is not patented. Like there is a one section 3 which says about subject matters which are not patentable. We will take through that all sections where many things related to agriculture, pharma, and any other improvement. These are some points Indian government or law says it is not patented, but there are ways to get some patent. So that strategy how to make, so that part we have to see. First thing we need to understand, writing a patent, it is not a like rocket science. First, it is a kind of, you have to understand your invention, and there are certain guidelines in the patent law. As per guidelines, you have to draft your patent, and the patent application, once you have drafted, it is all okay. And there you have to do your analysis with respect to prior art, lot of other things. I'll take through that all things one by one, and we have other slides as well. And what is the basic question that comes arise, like whenever people, any academic person or researcher, they look for patent, first they have to see what kind of problem they are actually solving, because patent is granted for solving the problem, because there the inventive step comes. So it is easy to convince the examiner if you have some solution. What was the like, there was some problem in the prior art, and there you have to see this is the solution you are providing, and it was not there, the solution was not there. So this is the best approach you should follow. So whenever you are thinking about, and any it is one more recommendation I have, if any researcher like PhD students and any postdoc student, if they are looking for any research, they should do, they should go for the kind of first prior art searches. They should collect the all the data from the prior art, and subsequently they have to evaluate all the things, and things which is not disclosed in the prior art, which is not there in the prior art, after evaluation you are getting these are the some problems in this prior arts, and out of that you can think of the new solution. So that is the correct way of thinking, the way industry works. And even if you go to US, Europe, and big institutions, they work like this. First you need to identify the problem. Solution comes when you identify the problem. So this is the major aspect we have to learn. Then whenever we have invention with us, first if we are ready with the filing of patent, because there are some subject matter in medicine, like we will talk subsequently, which are not comes under the patent, you cannot file the patent on that. So you have to look for copyright. So that way you have to filter that ideas, and then followed by there are certain principles you have to follow. You have to understand your invention. So whenever you have invention, firstly you have to define the you have to conceptualize that invention. Means, like suppose you get any solution, so there might be some principles you are playing, you are changing some principles which was not exactly there in the prior art. Prior art means before whatever you are doing, before that art was there, which was we are telling again and again as a prior art. So if that solution was not there in the prior art, you took that solution. So what was the change you have done? Because small changes is not like, suppose somebody is changing, I am making some new process where I change the catalyst of any chemical reaction, I change the solvent. What that solvent is changing, why this improvement is coming, that you have to understand, and based on that you can draft the patent. Because in the patent, it is a legal document, you have to conceptualize, you have to broaden the invention. Because we have to give one example, but we can cover a lot of other things. That claim part we need to understand, so that way it will come under drafting, how to draft the claim, so that we will cover in subsequent slide. Now I have already talked on the patentability with the subject matter, so you have to see your prior arts thoroughly. You should know all the prior arts. if you are continuously doing research, you have to track whatever the new publications are coming in that the same field, and you should aware ki this is the publication, it was done by that company, that competitor, you know the authors. So definitely there are a lot of systems are there, Google Alert, lot of other things you can see. So continuous tracking is required, because you should know ki like whatever you are doing, other guy is also doing. If they publish first, they file first, so then your invention is not worth. So that way you have to see, and this is the commercial world, and this is a commercial tool. Patent is a highly commercial tool. The big companies, they are driving lot of earnings out of that patent protection. So this is the thing. Finally, once in a while, I have some people, they ask question, we want to file the international patent. So I want to clear here, there is no international granted patent. There is a procedure where they are facilitating the patent filing process. That organization name is World Intellectual Property Organization, and they are kind of they are facilitating this patent filing internationally. They have a convention, PCT convention, Patent Cooperation Treaty. Under that treaty, almost more than 190 countries it is there. So point is that like these countries, they can collaborate, they can support you, they can consider you, you are a kind of citizen for that country. Whatever rights they are providing to that their citizen, they can consider you because they have signed the treaty. But there's no international patent. You have to go to individual patent office, you have to file your patent, you have to pay the cost. And I'm telling you, developing countries has lesser cost of patent filing. Developed country has huge cost. Even first you file the patent, subsequently you file the request for examination, subsequently you get granted. If anyways you have to maintain your patent, so there is a maintenance cost you have to pay. Even the big companies. So why I'm telling you, so I am recommending we should file the patent, but we have to strategize where our invention, where this invention is worth to file the patent. We have to decide the territories, which territories are in our interest. Because if we are filing the patent in certain territories where we are never going, so why we are spending our money? Because ultimately it is not a kind of one-time fees, it is a dynamic fees you have to pay continuously. So that way you have to decide on these matters as well. If you are getting some funding agencies, they are supporting for that invention. If you are assigning these inventions to some big organizations, so that way they will take care, they have their IP system. So these things should come before filing the patent. What is the worth of that patent? What is the, if you are getting some solution, who will be the kind of your customers? Are they able to afford? Are you able to get whatever revenue you are looking for? So, and you have to talk with the relevant people so that they can support you somewhere in the funding part. Because Indian filing you can do prior art in provisional filing. Indian costing is not too much, but when it comes to international cost, it is a huge cost. So even the big companies, they cannot afford the patent in every country. So they are filing based on their interest. So these are the key elements we have to consider. So with this note, I am going ahead. So now there's a, whenever we are thinking of filing our patent, so we have prior art with us. We had discussion here. In the prior art journal article, any website disclosure, any kind of disclosure in public, it consider even the public use. If you are selling your product and after that you are going for patent, if somebody else is producing these documents, you are already selling this product and now you are going for the patent filing, so it will consider as a prior art and you will not get the grant of that patent because you have disclosed your invention somewhere. So that there are definitions in every country, what is prior art disclosures. Normally journal articles we should not file before patent filing. First we have to file the patent application. Or if we are considering, like suppose we are looking for any patent or we have some invention, so in that whatever documents are there, if you that patent is from US or Europe, in that patent itself they disclose some relevant prior arts. So these documents are very important for us if you got any relevant prior art, because they give you the exact prior art. Because we see what is the problem in chemistry, everything was defined. You can search by chemical structure, that there are databases, you can search for it. But in certain domains, like suppose somebody is inventing on mobile cover, so that kind of searching and getting the correct patent, it is a big deal. You talk about any patent agent, they are also struggling, because you see, first, in not every country is speaking, they don't have the native language English, so they are creating things in their own native language, and translating all data in English is sometimes is very difficult, like China or Japan. So Japanese, it is a very difficult language, and they do a lot of innovations. You see, Japan is a country, they do a lot of innovations. So that way, it is a very like important aspect. You collect all the data in one place and make one summary. These are the things is disclosed in the prior art, and whatever inventions you have, you uh, you match it, and whatever the overlap will be there, which you are thinking it was novel, but it was not novel. So that you have to make that exceptions in your patent filing, and that way you will have the like this invention part, where you can draft your claim, you can draft your specification. But in the patent application, while you are drafting, you have to talk about the entire circles, two circles with overlap. So your claim will be the invention, whatever it is not overlapped, and that overlap part you have to consider in the prior art, and that all prior arts in the background you have to disclose. So these are the things we have to understand. Now already we had discussion, these are the slides with respect to criteria of patenting. So every country almost have the same criteria. They use some different ways to define these terms, like novelty or inventive step. Sometimes we see known obviousness, and there are in US there is a word called prosita, person ordinary skilled in the art. So that means like if you are innovating something and you are considering it is novel, or you found it is novel, but still it should not be like this, like it is a very obvious to get that solution for the person skilled in the art. Means, like suppose one person is chemist, and they already, there is already process which was running in ethanol solvent, but now you are taking isopropanol alcohol or some other kind of alcohol, methanol or any other alcohol, but you are just changing the solvent. So that in that case you get novelty, but you will not get the inventive step, because it is a very common thing for the person skilled in the art to change the category of solvent in the same category. So it should function like this. So this is the another way, so that way we have to take care while drafting the patent, because ultimately it will come to examination and you will not get the grant. Industrial application, definitely it will be there. In the life sciences we have always have applications, so this is not the problem in our industry. So in life sciences, in pharma, medicine, you always have the application. So these are the some industrial application we should have, so that way it will be there. So now this slide I have taken through Novartis. So they have published some data, and out of that I did some value addition on the slide. So they want to tell us what kind of patent normally file in the industry, in pharma industry or medical industry. So these are the detailed factograph kind of thing. You can understand like how they initiate the drug discovery, how it happens, and what kind of things they claim in a first day. And sir was using Bhagwati sir was using evergreening. So what is evergreening? Why they look for another patent, why they extend the life of that protection, so that they will get the monopoly right for a more time. So they will earn more, because innovator is normally they did huge investment. Even we don't have the companies like kind of Pfizer, or they are not actually from India, or like they are from US or Europe. So point is that it is a huge investment. They also need a return, but at the same time they have to see some harmonization where the developing nation who not afford the big cost, for that they should not do these activities. So by law, Indian government has taken care. Sir has given the example of mesylate. What was that? Imatinib mesylate. So it was a big case, landmark case from Indian Supreme Court, and where it was patent was denied for a subsequent beta crystalline form of that imatinib mesylate. So to start with, initially they file for the molecule patent, and a molecule patent also has like if it is a chemical molecule, so that way they file the Marcus formula. This is a Marcus structure because some variables are there. So with that structure, they claim that compound as a product. Product means nobody after that patent filing can make that chemical itself. It doesn't matter for any use. You cannot use that chemical, you cannot make, and you cannot sell for commercial purpose. Only the research and academic use is allowed. It comes under disclaimer because it is allowed for academic purpose. Otherwise you cannot use that compound. So this such kind of claims, we say product claims in pharma world, and this is the first claim, and this is a kind of showstopper. Till the time this patent is valid, no generic player can enter into the market. So this is the first primary thing. But in case of proteins, because these days many anti-cancer drugs, you see these are different proteins are coming, and they have sequences, they claim sequences, DNA, RNA, DNA sequences, and whatever the protein sequence it will be. So such kind of claims are also there. And these are like so there are many big blockbusters products are there in the pharma world these days. So in pharma, normally when we are talking about generic business, it is a chemical compound followed by whatever generic comes, we say generics. In case of that protein, whatever generic comes, we say biosimilar, because exact copy you cannot make because it is a process dependent products. So these all comes under the this like molecule patent. So this is a first patent file by innovator, and normally this is the process. Subsequently, what kind of patent they file? They go for like suppose first day they have filed these patents, and subsequently after 2 years or 3 years they file for composition and formulation patent, where they are claiming formulation of that compound whichever they are claiming in the molecule patent. So that specific compound they take, they make different formulation like extended release formulation, gel patch, anything, any new formulation which is convenient. So they file the formulation or composition patent. It is a synonymous word. So these second patent will be kind of composition or method of use patent. Then subsequently they look for a specific form patent. It is enantiomers. Enantiomers means they have some chirality, and out of that chirality they have different structures of same compound, so that may have different activity. So that activity, if they are showing enhanced activity, they can file another patent, and that will extend the expiry of basic molecule patent. So that way that continuous that they file polymorph patent, new salt ester. In case of imatinib mesylate, Novartis was filing the salt patent, and this also have beta crystalline, means this was a salt crystalline patent. So that way continuously life they can extend, and they are extending. So this is another. And prodrug, you know that it is subsequently converted into the body into the drug. So it is a moiety, some esters, and attached to that normal molecule, and that is hydrolyzed, and subsequently the normal drug is available in the body for the activity. So that this prodrug comes like it is also a kind of they look for patent subsequently if it is there. So if that option is there is a one product in pharma, Apri patent and Fossa Apri patent. So Fossa Apri patent, it is nothing but it is a prodrug of Apri patent. So that way, this pharma world, they continuously look for new IP protection for existing molecules, so they can bring continuous business for their companies. So this is the way they file. Now it comes about the process part. So in the process part, after, like, suppose one patent can be expired in 20 years. After the 20 year, these generic players comes, and innovators is also there. They also file their own patent. So that way they've also filed some manufacturing patent, innovator manufacturing patent, purification patent, some diagnostic process patents. So they file. But at the same time, whenever any generic company, like suppose from India, Sun Pharma, or any other company, Zydus, Alembic, or Wockhardt, Glenmark, whatever, so they also file their patent for whatever improvement they are doing for new process or new formulation or whatever it is. So that protection, it will be there for these companies. So they can enjoy their monopoly for that kind of whatever improvement they are doing. But basic molecule, it will be free, because 20 year is completed. And then there are server asking what kind of patent like we can file for this medicinal surgery or some new things, or like suppose there are molecules, some specific dose regimen, lot of patent people are filing. So these patent normally in one category we see method of use patent, we say. So method of use patent are not allowed here in India, but in India, if somebody is interested, so they can file their priority application with India, and they can have the granted patent in US, Europe, Japan, Australia, Canada. So all developing countries, they give method of use protection as well. So, and India is the kind of we have different market, so that way it is not allowed as per the patent act. But definitely you can file your invention here in India, because definitely we have to do this activity. If some Indian citizen is directly filing the patent in any other country, they have to take permission from the controller. So there is a specific form, I think I'll tell you in subsequent slides. So that way it is allowed. And now there is a very similar segment related to agro, or related to pharma, is agrochemicals. So there they use different pesticide as a combinations. So that synergistic combinations, it is very much required there, because they have to apply these pesticide in a huge field. And if 2 times 3 times they are doing the same activity, it will cost. Okay, so that way these combinations patents as a value added patent or subsequent patent, it may come in agrochemicals. Even in pharma, if some dose regimen is required to have 2 combinations, like many hypertensive drugs you see, it comes as a combination. So that combination of one AI to another AI means active ingredient. So that way you can combine 2 drugs, and you should get some additional advantage. So that is called as a synergistic means it should give 1 plus 1 equal to, it should be 2, but if you are getting 3 or 4, so that is a kind of synergy you are getting. So that synergy patents definitely you can get as a new patent subsequently after the molecule patent. So these are the things, and some other patents will look. So this is a overall cycle for life sciences segment, and I got it. So I just want to show you like what kind of patents are there. Now, especially talking about doctors and whosoever is doing such kind of research in medicine profession. So what kind of patent they can look? They are continuously improving in the device segment, whatever devices they are using. So that device they can file as a device patent. So definitely they can go for that patenting. Just that they have to see how they should claim. Sometimes the product claims are not allowed, but process claims are allowed. Sometime if that process, whatever you are claiming here as a product here in India, I'm telling about the way how to get granted of such kind of claims which are not patentable here in India directly. But if you connect these claims with some drug or some specific therapy or there are ways. So that way you can try, and some people may get the granted patent as well. But in other countries where directly these subject matters are allowed, you will have the granted patent on day first, or the way you want to claim, you can claim. So they go for device claim, they go for process method of use claims, they go for combination or system claims. You see, these are all medical devices or kits. And what kind of claims they are getting, I have written here. These are the product claim, these are the product claims. So exact product you cannot make, nobody can make. So and you will get the protection. And you see, this medical world, it is a global world. We don't want to protect anything here in India only. We want to commercialize such kind of products globally. So major countries where major earning comes, definitely you get that protection in that country. So there is no question about that. So there is a way, but you have to tackle this Indian scenario or developing country scenario, and you can file your inventions, medical device related as well, through Indian channel. So that is not a problem. Industry is already doing. So, but you have to dig a lot. You have to see what is the kind of advantage you will get, and based on that, you can spend your money. Now we have already had discussion. There are different kind of patent application we can file with the Indian Patent Office. So provisional or non-provisional means it is a complete specification, and there are some different subcategories of non-provisional application, because if somebody is filing from as a US as a citizen, and they are filing their patent application here in India, so they have to come through some channel. So these are the convention applications. This is a direct international applications. This is a PCT, means it is an international application. So you get added time, 31-month time to file their invention in all the countries. So these are the added, and some cost wise, definitely you will get some advantage. So it is already there. Some patent of addition, like suppose if somebody has filed the invention today as a complete, but tomorrow he thinks that he has some better idea. So in Indian patent system, you have option to file patent of addition, where you can add subsequently whatever new things it will be there. Again, it will be examined, but you will get the additional protection. But the lifespan of that protection will not extend the protection whatever it was there with the parent application. Means the expiry of the patent will be the same whatsoever it was there with the parent application. And in the patent of application, your parent application will be cited in the bibliography. So that way you have to see. Now there is a form 25 which I was talking about. If somebody is interested to file the invention directly in US, Europe, Canada, Japan, or any other country other than India, so directly, so they have to take permission. They have to fill form 25, and they can take the permission from the controller, or it will be allowed, because there are certain clause provisions like Atomic Act related, and there are various provisions where such kind of applications like they are tracking these systems, because such kind of inventions they will not allow to publish in any other country. So that way you have to take permission from the controller. Now inventions which are not patentable, because if we are drafting the invention and our invention is not patentable here in India, how we should draft the patent? So first we have to understand what is not patentable. So section 3D, Bhagwati sir was elaborating huge case of Novartis imatinib mesylate. So it was based on section 3D. So any new form of known substance which is not patentable, so that is understood here. Section 3D, it talks about, like there are a lot of sections, you can read it out. So I will just take the important ones so that we will finish this on time. So any new substance or new form of non-substance, it is not patentable. Otherwise, you have to show the efficacy. Efficacy doesn't defined in the law, but it is depend upon like the whatever it was there in the prior art, what kind of advantage you are showing, and it is if it is a exceptional advantage, or it is over the examiner how he look for. Sometimes people get this kind of claims granted, sometimes not. So it is depend upon the case to case basis what kind of advantage you are showing. And sometimes government or government is taking or involved in such kind of decisions. So it is a kind of policy matter. Otherwise, as a clear-cut law, new form means any polymorphic form, any salt, any ester, any solvent, any kind of new substance or new form of known substance, it is not eligible for getting patented here in India as product. But process patent you can file. So here there is a clause. People are looking for the product patent. So product patent you will not get, but at the same time, process of making you can get. So how to play with this law, you have to understand. So these are the, like, there are some like broadly there is a IP, but if you go to in depth in the subject matter, you have to understand how to play between the lines. So that way, and sometimes process is so critical. If you are claiming process, that your product cannot be make. So if you are getting the process claim, it is equivalent to product claim. So that way people have to understand. And subsequently, method of agriculture and horticulture is not allowed. So directly you cannot file, but there are ways people can think of. If they are applying that process, and that process somewhere it is connected to some specific pesticide or some specific agrochemical. So that way you can think of, you can draft a claim such a way that it should not look like it is a method of agriculture or horticulture. So that way you can work on that kind of part. So there are other sections as well. So here it is clearly written in section 3I, any process of medical, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings are not patentable. And these are the explanation, it is clearly written. So that way you have to understand directly these inventions are not patentable here in India, but in certain cases, most of the cases in developed nation, you will get the granted patent. And India is not only the market, but there are other ways also. So it is depend upon the case to case basis. If that case is there, and I am telling you, applicant is always free to file the invention, but there is a value or there is a need for experts sometime, because in day-to-day life we will not get such kind of exposure where such kind of drafting can be done, because it is not a sometimes it is not a very simple thing. You have to think a lot, you have to like you need lawyers. So that way these patent agents is also necessary. So if your case is critical, so I'm just recommending, if you need any help, you should take help, because it is worth to have the help. It is not about the filing one invention with the patent office. It is a simple form uploading process anyone can do, and you can pay the fees. But once you have uploaded, you cannot change anything. Because if you are looking for some commercial thing, you have to think what you have uploaded, because you cannot change anything, nobody will listen. So this is the thing, you have to play with the like whatever study, you have to make the strategy first. Then plant and animal as a whole, or any part other than microorganisms but not included seed varieties, species, these are not patentable in here in India. Whatever the subject matter we are looking for, the copyright, like literary, dramatic, musical work, artistic work, it is not patentable here in India. So such kind of patent drafting is not required. So and at the same time, Bhagwati sir was telling a lot of things related to biological changes, where you can manipulate the change, and then subsequently people look for patent. So in some countries you can get such kind of patent, but in Indian scenario, sometime it is a policy matters, and government has take normally such decisions. So based on their needs, they go for. But globally, if you are talking about your invention, if it is working globally, you can look for the global market, and there you will get all kind of protection. And over the time, I'll tell you, it will the things will also improve here in India, because it is always depend upon the kind of infrastructure we have here in India. If our population cannot afford that kind of monopoly, or what kind of these big innovator companies from the global market, they want more earning. So if we are able to pay, then government stand will also change in future as well. So these are the things it will come in future. So these are some granted patents. So it is just a copy for your what kind of granted final certificates we get in the patent. It is an Indian patent. It is a US patent. Now this is like, suppose we get some patents, we get some prior art, somebody has filed the patent in US. This is the US granted patent. Here there are some codes. Why we are reading these codes? Because in some countries we cannot read their language. They are writing invention in Japanese, they are writing inventions in Chinese, even the dates they are writing in their fonts. So in that case, there is a uniform system called International Agreed Number for Identification of Bibliographic Data. So this is the line. So in that line, these numbers, it is formalized by the WIPO, and you see that that number, it is rare, like 22 number, it is related to application date. So that reading is required, because we have to see when this invention, whatever you were thinking as a prior art, or it was not a prior art, or whatever it is, you have to understand that document. So for understanding these basic things, you have to understand. So these are the different codes, and based on that code, you have to read these specification in other countries as well. And you can take your technical note, where you can write this prior art was published 1 year ago, 2 year ago, 3 year ago, or what it was published. So that way we have to collect the entire data in one note. So that way this information is required. So that is what I am displaying here. Now we are talking about the prior art, how to get the relevant prior art, because without prior art you cannot talk about the patent drafting. So this is one US granted patent. You can see here, even this in the granted patent, this is the granted number, this is the granted number, this was the date of grant, this 22 number is a date of filing. So here they are disclosing all the relevant prior art related to that invention. So it is a kind of ready-made thing where we can collect our prior arts, and even in the background of that patent you can get some idea about the prior art, what was disclosed in that prior art, and based on that you can conclude your about your invention. Yeah, if that patent is crucial, or before that patent there might be some other patent or other journal article which may come for your consideration. If it is like it is relevant to whatever you are doing, you are inventing something. So that way these all articles, journal, patents, you have to read, you have to collect, you can make one file, you can make some dossier kind of thing, and that final you have to make some patentability report. So it is not about the filing a patent, it is a first, what is the steps we follow normally for filing a patent. First is kind of you have to search your prior arts. Second step, you have to make some report which is called as a patentability report. And then subsequently, if that patentability report is positive, then only you can file your invention. Otherwise, you can file the invention, which doesn't mean anything. Filing a invention, it does not give you guarantee you will get the granted patent. It is just a paper filing. If you are not filing request for examination, you will never get the granted patent on. Give me a minute. Okay. Done. So now again, it is a one international application. I was telling you, it was, you can see that it was written in Urdu, and it was filed by some different country, and that invention you have to read. Finally, it was published in PCT and WIPO, so it is an international PCT application. So we can read some part in English, but only that part will be there in English. Other things, description, there are different segments of any patent document that we will talk in subsequent slides. that we cannot read because it is there in their native language. So that way sometimes it is critical, so you should know. And these are the Indian patent filing. So these are the some pictures I am showing you, so that you should know ki these are the way of their country publications. This is a Canada patent of some device. So, and this is a European patent. So in Europe, this European patent you can have, because there are many territories, but they have some centralized procedure. If European patent office is granting any patent, it will be applied for to every single country of Europe. So this is there in Europe, but there is no international patent itself. Means international granted patent you cannot have, but at the same time in Europe, individual country you can go, you can file your invention, or otherwise you can grant, you want to grant a patent for the entire Europe, you can get that kind of patent. It is allowed because they have one centralized patent office. It is, if they get granted this patent, any patent, so it will be granted in across the Europe. So that way it is there. Now we are talking about the claims. So when we talk about like, I think we should take that slide first. Give me a minute. Yeah. So this is the structure of any patent, or when we are talking about patent writing. So like first, if we are like, we did all the job of like patentability. We know our invention is novel, and we have differentiated prior art versus our invention, and we found the gap, and out of that gap we can draft our claims, because claim is the heart of the patent. Means claim is something you will get the legal protection. Other part, whatever you will write, it is a just for understanding you are writing. But claim is the actual thing where you are defining your boundaries, and you are writing and whatever claim will be allowed after examination, that will be the kind of legal protection you will get. So claim is very, very important. So to draft a claim, you have to understand how to draft a different claim. So this is the basic structure of any patent application, where you have to write the title of the invention, you have to write the technical field of the invention. In the background, you have to write all the prior arts related to invention. You have to describe. We will see some live examples. In the summary of invention, what kind of things you have to write, because you have already summarized the background of the invention here. So once you have examined all the prior arts, you know that was the prior art, and that was the, in the prior art, what was the problem, and these problems you will cite here in the technical problem. As a problem you will cite, then you will cite your solution, and then you can start writing about your invention and what is the advantage you are getting out of your invention. Then it is a continuous process, it is a document. You have to continuously write your document in that sequence, and that document may be 400-page document. It doesn't mean anything. You can file the patent for like it may be the 1000 pages. You have to pay additionally, but it doesn't stop you to doing anything. Then if your invention needs any drawing or description, like you have to describe your invention by drawing, because suppose if we are claiming any device, so definitely that scratch we have to make, and that scratch we have to put in patent application. In chemistry, people can be like, they can put their schemes. So we will have some live examples where we will see how people are drawing the schemes, chemical schemes. So that way, sometime for device or some subject matter where we need pictures to define our invention, where we can have some drawings as well. Examples. What is the meaning of examples? Example means it is a real lab work where you are giving the exact example. Like suppose in Marcus, we are talking about the Marcus structure. I think chemistry people will understand more, but if some pharmacists are there, they will understand. Like if any Marcus will be there, there will be thousands of chemical other structure. It may be covered because everything is undefined. R1, R2. It is defined in a broad sense. But out of that, you are making only 2 compounds, but you are defining the big structure. So this is the way in the chemistry we file the patents. So that way exact invention you have to define means exact compounds. Here you have to exemplify what is the exact procedure you have taken for that invention. And then we will have some live session where we will see like how people are drafting. So this is the basic structure of the patent. So now I am again going to the claim part here. So like I have already told you, there are different kind of claims as per need we have to adapt, but there are basic need of claims when we are talking about claims. So claim is the same subject matter. It defines the boundaries. There are different ways to write the claims, how to draft the claim, that you have to decide. So claim, normally you have independent claims and dependent claims. So independent claims means first claim will be the independent claim, or there are more independent claim is possible in one application. Like suppose any compound or any process you want to claim, it will be claimed as a independent claim. First claim will be like this. Dependent claims defines the independent claim, further defines the independent claim, means which is there are some essential element of your whatever the scope you want to cover, it will come under the independent claim. Whatever the description or other element will be there, which you need to define, but it is not a necessary element, so that you can cover independent claims referring to the independent claim. So that we will take, once we will take the example, we will understand more. For the time being, you take like this. Omnibus claims, these days it is not allowed. These are very broad claims. Sometimes people were referring the claims to some drawing or some non, you cannot define these boundaries. So that is why these considered as a very vague claims. So such kind of claims these days are nobody is using. So these are some type of claims. I was just elaborating. Now there are different kind of claims we need to understand. As per need, we sometimes we have to adapt. Like suppose if our invention is about improvisation or modification of existing technology. So the way we are writing here, like this is the punchline, first line, and after that our element will come, whatever invention element will be. So here a system for storing information having certain elements, whatever you will see, it is a important novel elements wherein whatever improvement you have done. So such a way, there is a definition in the law, international, there is a international precedent cases in patent. So based on that, judge has put it like US court and Europe, judge has put it some remark and they have named that claim, so Jepson claim. Same way in pharma world, we are using Marcus claims for chemistry. So whatever new compound comes as if it will have some efficacy, it will have some activity like anti-hypertensive, anti-analgesic, or whatever it is. So that way they can claim as a product. So that is a kind of Marcus claim where these R1, R2 is not, it is defined subsequently. So here in one structure they can define thousands of different compounds. So these are the broad claims, but it is allowed in drug discovery because drug discovery is a huge process. It took almost 10 years to develop a single molecule, and they may scan thousands of molecules to get a single molecule. So it is not an easy process. In that case, the law is also flexible. Internationally, such kind of claims are acceptable in the chemical world. In other cases, things are not like this because here a lot of things are on stake. In medicine, if you want to test such kind of compound, so it is very difficult. There are human, animals, such kind of things are involved. So the law is quite facilitating this process. So that way it is there. Swiss claims, like suppose such kind of claims, Swiss claims, it is a second method of use claims. Like suppose one compound having some new use which was not known in the prior art. How to claim that kind of new use of that product? So that way it is a Swiss claims. It is allowed in Europe. In US it is allowed, but in India, I think you have to draft some different way. You can get such kind of claims, but direct it is not allowed. Means method of use claims it is not allowed here in India, but second use it is allowed. You have to add some formulation limitation in the claim, then you can have such kind of claims. Maybe the scope sometime you have to see what kind of things are there where you can play. So it is depend upon the case to case basis, but in Europe the Swiss claims it is allowed, second method of use of same compound. Now we have discussion, already many people have elaborated about the product claims. We have also had discussion where we are blocking as a product anything. So this is a product claim. Process claim, you are defining the process where you are claiming the process. You are actually claiming the step by step what kind of things you have to follow to get some product out of that. So that is a process claims. Now there's a product by process claims. So product by process claims where it is required. In biotechnology industry, it is very much required, because in biotech industry, this different biotechnology process is depend upon the, like their product is always depend upon the process, because they use microorganism, they use some gene manipulation, they use different ways, but it is always a process driven products. So in that case, whatever the product they are achieving, it can be achieved only by following that specific process, and it is not a easy, it is a very complicated processes where special plants they have to establish, and after that this product can be manufactured. So that way it is very costly process. Only few companies here in India, Biocon, Vocard, only they have set up there is a Intas in Gujarat, they have set Reliance Life Sciences, they are also working on biotechnology products. So very few companies can work in that segment, it is a very costly affair. So in that, this product by process claims normally comes. In chemistry it rarely happens, but still it is possible. In chemistry also you can get product by process claims. Okay, we will have some examples. Like suppose the composition claims, it is a formulation claims. So it is a clear cut, you have some you have your compound, fine API compound, active pharmaceutical ingredient. So there you will have your compound with excipient, different excipient. You can claim your formulation as product, and this is called as a composition or formulation claim. So this is kind of claim we can draft. Mean function claim, it is also a one kind of claim, but right now it is not needed. I have just covered here because it is a lot of data. So now we are going through. So now we are talking about the patent specification. So I have taken some screenshots here. We will understand how to see or what kind of things we have to draft. So in the patent specification, you see this is the way, it is a US patent I have taken, because ultimately you see how, like when we are going for patent drafting, so there might be some Indian way of patent drafting. There are different people, they use different ways of like patent drafting. They use different headings. Somebody is writing preamble, somebody is writing it is a field of invention. So there are different ways of writing same thing. So but what happens if you are writing the way PCT accept or WIPO accept, or we may say international patent application, whatever the way it should be written, so same way it will be adapted in every country. So normally in industry adopts the PCT patent filing system, and we file the invention, and the things are same. It is just a like the way you are writing. So every writing may be different, but there is a clear cut structure, harmonized structure. It was suggested by PCT, so that structure we can follow. And these big countries already following this PCT structure, or even here in India, if you file your patent with the PCT structure, it is very much acceptable, and there will be no issue because we are also a part of PCT convention. So here you can see your description. It is elaborated how people are writing these things. We'll take some more example. now I'll take you through the writing of claims, how to write the claims, what is the structure of any dependent or independent claim. So we are talking about independent claim. So there is a element called, first you have to define your whatever your you have process or you have product which you are defining, and after that these transition words comes. This transition words is actually they are defining the boundaries of your invention. So what happens, like suppose you are using there are some words people use as a transition words. What is that transition word? We need to understand first. So in the transition words, what happens? I'll tell you. Yeah. So this is the transition words. So comprising, consisting of. Okay. So these are the, and these are, I think I have repeated 2 times. Comprising and consisting of. These are 2 transition words. There are some more, but normally 80% this comprises word people follow. In Europe, this consisting of sometime some examiners use. Comprising, it is a broad word. When you say the process for the preparation of paracetamol, comprising means whatever, and after that comprising you will say step A, step B, step C, step D, whatever it is. You have 4-5 steps. If somebody is using step E and he's telling, I'm not using your process because I am adding some new like step in that. But in comprises word you cannot do like this, because comprises word is an open-ended word. It is defined in the law. So comprises, it is a most recommended word. We should use the comprises word. If you are using the consisting of word, in that case it is a close-ended word. Means where you are defining your boundaries, you cannot go beyond. If somebody is adding some element on your whatever you have made, and he will use your invention, he will add one extra element in that, and then he will commercialize. So he will not infringe your patent. So that way we have to see the enforceability of while patent drafting. So that way these transition words are very important. My recommendation, we should use the comprises word more frequently. Now you see, this is the claim we want to draft. So here you see how people are drafting these Marcos claims. I have taken the example of omeprazole. So it is a azole one compound. So how people are filing such kind of claims? So if they want to file, first day they file for Marcos formula. So this is a Marcos formula. There is a compound of formula 1 having this structure. It was elaborated, and these all things like X, Y, Z, it is defined under this definition. So that way you can claim as a chemical this product. Okay. So this is one way of claim, and it is considered as a molecule patent or the compound patent. There is another way, like suppose the same, it is a 2 different example of same kind of claim. So again you can see the one live example of omeprazole where such kind of claim was there as a molecule patent, and they have claimed, and these all functional group which can be connected like this, it is defined here in the definition. So these are the compound claims. Now we are talking about the formulation claims, and there are different like as per definitions. We have to read the description, specification, how to write these specification while writing, because it is a complicated matter, scientific matter. Okay. So it is never a if you don't understand, you cannot write your invention, because you see that defining these definition, making everything conceptualize, it takes a lot of understanding. So that way we have to understand. Here we are claiming one formulation, a pharmaceutical composition useful for the depression, and here we are giving that structure. It is a broad formulation claim, means composition claim. So that way definitely we can file the formulation patent on day 1. So any big company will come with new compound after molecule patent, they will file this formulation claim. But if subsequently, if Indian any generic company, they are looking for any patent or new technology, which is called as a selection patent over this, because this invention, it was a Marcus formula. Every single innovation it is covered. Means if any formulation, whatever you will make, if that compound will be there, it is covered. But this patent somehow it will be going to expire in 20 years. And then subsequently these generic player may have the chance they will do some other value addition. It is always possible, so that they will do that selection patent. Selection patent means there is a one parent patent where broadly things were disclosed, and now subsequently you are filing the selection patent. You are making some specific technology which has some utility, some usefulness, and based on that you are filing. So here you see that here in the element, whatever the ophthalmological acceptable non-steroidal anti-inflammatory drug formulation is there, here we are writing some limitation. We are using in certain concentration only. These are all limitations. So such a way we have to draft our invention. So we have to conceptualize whatever elements we are using, or that is depend upon the kind of subject matter we are thinking to claim. Like suppose if you are going for some different segment patent, there are different things you need to consider. First you have to understand uh, what was the invention, what was the prior art, and based on that what was coming into the filter. And then you have to define your boundaries, and that how to write these boundaries. So that definition you have to create, and you can write your own. There is nothing you have to follow the book and something. You can define, if I am writing this, you should understand these things in that manner. So that description you will have all the rights. You can write your terminology, you can define your terminology, and every terminology whatever you are using continuously, same way you have to adapt in across, like throughout the your specification, patent specification. Now we are talking about method of treatment claim. So here we are giving one compound for the treating something, some disease. So it is about the bacterial infection. So here you see that a method for the treating or preventing a bacterial infection. So this is method of treating claim we want to write, and comprising it is a transition word. We use that, and then subsequently whatever you are doing, it may come like this. So this is called as a method of use claim. So it is like it is for understanding. So now we will take some live case for like just after that I'll take. So this is one more thing for the chemistry people I want to give, or chemistry or pharmaceutical chemistry. So here you see the what is the meaning of, or other people will understand like what I am saying here. What is the utility of these patents, or how to conceptualize whatever invention you have. So like suppose whenever we are going in lab and we have some invention with us, and we want to go for patent filing, so we need to draft our invention. So this is the common way we write our inventions steps. What is happening? Step one, it is a final compound. So and in the final compound, we are converting these compound through some process. We have written oxidation, reduction, and again it is happening. So that way that process is there. You can see the arrows. So that arrows you have to define what is the meaning of, like if you are using some reagent, you have to understand what is happening in that reaction. Is it oxidation? Is it reduction? Is it hydrolysis? Whatever it is. And then the meaning of these oxidation reducing, you have to define in your description of your patent writing. Okay. And then you see that how people are drafting these inventions. So that element by element you have to split the invention, and you have to write in a certain way so that the person ordinary skilled in that art will understand what you are writing. I am not telling this claim will understood by anyone whosoever is not from the any technical background, but the person who is doing this activity routinely, he should able to understand what you are writing. And one more thing, we should not take every, like suppose in the prior art, no oxidizing agent was there to converting these compounds. So in that case, you have to pick, you have to see in the prior art what kind of oxidation agent was there. And that if you are and you see, if you observed, there was no oxidation agent was used. So entire oxidation you can claim. You should not go with the only one oxidizing agent. You can claim the entire oxidizing thing, and one enabling example, one example is sufficient for granting a patent. So that way you have to elaborate your invention more, you have to go in depth, and that way you will get the broader scope, and that scope you can have, because once you have the broad claim granted, nobody can design around your patent. Because otherwise what will happen, you are covering one oxidizing agent, one hydrolyzing agent, one reducing agent. Other people will use the same process, they will use the different hydrolyzing agent, they will tell ki we are not infringing your patent because you are not claiming this. So that way we have to understand, while writing the patent invention, these conceptualization we have to make properly, and there this drafting expertise will come. Or it is more depend what, like chemistry expertise, whatever subject matter you are writing, first you have to understand how to write that subject matter. So broadly, principally, you have to understand. So this is one thing. Again, I was trying to tell you same thing. So look for broad coverage here, inorganic, organic basis. You see that. So this was like initially you will start like this. Suppose you are using some base. Suppose I am using the pyridine thing, but I know I might be using some process of conversion where no base was used in the prior art. So I will try to cover inorganic base or organic base, and I will start my definition with the word base, where I will cover, it may be an organic base or organic base or inorganic base, whatever it will be, I will cover both the bases category wise. Then I will subsequently redefine. So that structuring you have to make. You have to make the hierarchy, and based on that hierarchy, you can draft your patent, and it will be kind of good patent where you will get the broad coverage. Same thing I am talking about the solvents here, what kind of solvent I was covering. So you see that first I am categorically I am covering alcohol, ketones, amides, and then these are the solvent I might be using. I have 3 examples only, but I may cover because it was not there in the prior, which I have already evaluated. So what was not there, entire thing I may cover, and I have done all the job, and this is what we can claim. So that kind of restructuring we have to do. So now we will go live. Will take one application. I have taken one application of Jubilant Life Sciences. It is one Indian generic company, Jubilant Group. Okay. So they file one US granted patent here in India. Sir, are you able to see my screen? Okay. So here, this is the patent I am just opening here for our purpose. Okay. So we will take it live now, this process. So here I am elaborating here the small things related to like the patent drafting. So it is a one US granted patent, and it doesn't mean anything. One Indian company only has filed this patent. So how to read this patent and how to write, we will talk more, and then we will complete this session. So here you see this is a title of the invention. Okay. So and while writing you need title, so that is required. Some details you are putting whenever you are filing, so it may automatically come. So everything you need not to write. We will see whatever the actual draft. So here is the abstract. So abstract will give you the essence, whatever the detailed process will be there, out of that what kind of product you are getting. So that entire thing you have to talk in abstract. So detail, summarized process or invention, whatever, or your improvement also you can write in very very You have to summarize this properly. So this is the one thing. Now to start with, field of invention. Field of invention, like suppose if somebody is doing invention which is related to pharmaceutical field, so you can write the field. So like if somebody is working in agrochemical field, they can write agrochemical, automotive, or automotive, medical, the whatever they want to define, they can write where this invention is going to be utilized. So that way you can write. Now you see, we are continuously talking about the prior art. So prior art, you see every invention they are defining, they are writing about that invention. These are the patents related to that invention, whatever they have filed. So there are several reported process they are telling. So such a way we have to write this sentences, and every single patent number or journal publication we have to write, and we have to elaborate what they have disclosed. And once you have done, and you can also elaborate their disadvantage while writing these patents. Okay, and once you have written all these things one by one, and whatever your understanding will be, and it should be correct, means you have to validate all these things, or so that way it is important. So because it might be if you are working in such a segment where nobody is working, you will not get that much prior arts. But if you are working where many people has already worked, so in that case, for filing an invention, you have to collect your prior arts, and it is recommended because it will ease your efforts as well, because subsequently examiner will ask you about every single prior art. They will cite you in first of a section. So instead of citing by the examiner, we should also disclose, and it is a kind of duty of conduct of the applicant. They should disclose all the data to the patent office, whatever relevant data it will be. So these invention you can write with their process. If there is any disadvantage, you can elaborate, and subsequently you can give your final thing, like why your invention is required in that field, what kind of advantage you will get, what advantage people will have out of your invention. So that kind of thing you can elaborate in the last of the background section. Then you will write summary of your invention. Summary of invention, it is nothing but you can take your abstract, that abstract first embodiment you can make. In the summary embodiment, first you will understand there is a way of writing in the patent application, where we normally take the embodiments. So embodiments means different sections of the patent where we are writing the invention in element by element basis. So first broad invention you are covering, subsequently you can remove some you can elaborate whatever new some definitions because you are using. So here you will further define your definition, what was the solvent definition, what was the base definition, what was the API means, whatever you are using, and continuously you will write in a you will make embodiment of every aspect of invention, and then subsequently you will write the detail in description. But here I am telling you, it is not very much different from the research publication writing. Whatever we are doing, it is also a very much technical thing. If you are filing in JMC, Journal of Medicinal Chemistry, or ACS publications, definitely quality wise there was no difference as such. Even they may have the better quality journal wise, but here you have to split the data accordingly as per the requirement of the Patent Act. Okay, so here you see again in the detailed description, again the summary of invention you have to repeat, but here in detail you have to describe every single aspect of the invention. So here I am not taking every single aspect because it may, I am just losing my time because okay. So now once you have done this, these are the actual examples which we were telling about. So this is also a segment, and we have to enable the every single element of the example where exact process we should have. Here there are certain things we should take care as a chemist or as a pharmacist or whosoever. Whatever units we are using, it should be the same unit we should use. The writing we should do in the past sentence. Okay, and whatever the invention was there in the same hierarchy, we should give our example one by one. and that entire examples technically you can give. If you need any like NMR or IR spectra or any kind of spectra, XRD spectra, so that reference you can cite here, and subsequently you can put your whatever this spectra was. So that way the entire thing you have to give as an example. Though this is a real example. Here you are writing or finally after the example the claim part will be there. Here you can write your process with your proper transition word. You have to define your process, and in that you have to define your element. You have to define your dependent claim or independent claim. You see that what was there, this is the dependent claim. There is a no dependency here, but in the claim 2 you see this is the process according to the claim 1. So these are the all dependent claims. So this is the way of writing of dependent claims. So in the dependent claim we define what is not defined, just a term was there in the independent claim. That term subsequently we should define in the dependent claim. That is the function of independent claim. Or independent claim gives the broad thing, and it is a like first like your coverage will be this lines only. So that way you have to understand independent claim will give you the coverage, exact legal coverage, and that coverage, if somebody want to see your boundaries, they will look into the dependent claims. And if that is also not working, in the last they will read your specification as a whole if the case is that complicated. So that way it is a entire process of claim drafting. Or what I am requesting, if somebody is interested to file or draft their patent, they should actually see some more patents in that segment. Some international patent they can have, and there are some like agencies they are giving you. I am just opening here for like they can use their keywords or searches. There is a PCT scope, there is a one this is a WIPO website for patents. So where whatever invention they are doing, they can search here. Once they are searching for that invention, this is the link. Okay, so this link I am pasting here in the chat box. So once you can search your invention, whatever it is, and once, like suppose I am searching for apixaban, this is one anticoagulant drug. Once you have done it, you will get all the patents like international patents here. So that patent they should read, they should go for reading, because it is very much important how other people are writing about that invention if you are new drafter, because you have to read a lot, because it is a kind of new subject matter. Sometime if you are using some new technology, how to write that technology, you have to take some sample example. So through that sample example you will get some idea, and after that you can draft your patent thing. And I am again telling you, it is more it is a techno legal job. So again it is a kind of like you have to understand your invention thoroughly. It is not about only the legal aspect you have to take care, and then you have to put in the different basket elements you have to split, and accordingly you can draft your invention. So that way it is very much important, and somehow from strategy wise you can take from you can take some help from some patent agent who can help you, because like whatever invention may be, the current drafting or kind of claim we can file here in India, or whatever your strategy will be, it has to be decided properly. So this is all from my side. So I think if any question will be there, I am happy to answer. Anyone is here? Jay sir.
Yes, sir.
Yes, sir. So this is all from my side. I think you can complete if nobody is there.
Okay. So, first and foremost, a heartful thanks from my side and Dr. Agrawal's side to our beloved chairman, Shri Rahulji Agrawal Sahab, who always encourages such activities on every ground to support the last stage of the person who can take advantages from such events. A big thanks to Shri BP Sharma sir, who keeps the drive alive in all of us to think out of the box for such events. We must also thank Shri Gupta sir, Honorable Vice Chancellor, Pacific Medical University, who in collaboration with our university always encourages for such events. A heartfelt thanks to Shri Dr. K.K. Dave Sahab, who is always with us day and night for such events, as it takes lot of efforts, pains to make such events successful. And it is his blessing. He always is with us day and night, anytime. We are big thankful to you, sir, Professor Dave sir. Last but not the least, I would like to thank Dr. Ritesh Agrawal as well as Pratik Srivastav ji, who spared their valuable times out of this busy schedule and making such events successful takes lot of pains and energy. As a part of the team, I would like to thank Dr. Ritesh Agrawal, who is the head IPR Paher University. Since his association with the university and with us, he has always been providing new insights of the intellectual property. The event was like Dr. Agrawal given us insights of how we should look at a patent first. How we should look at a patent, because the drafting of the patent is like if a person starts reading it, he ends up with the first page only. So Dr. Agrawal gave us the insight that how you should start looking at the patent. What are the basic things which you must concentrate so that you can go through the critics of the patent. Pratik ji explained it in a workshop manner that how we should go with different forms, what are the minimum requirements which are to be filled in the forms, what are the fee relaxations with the universities, government bodies as an individual. So these are various insights which you will not find on Google also. So I would like to congratulate each and every participant that they have participated in this event, and I am sure that you have noted certain things which you will not find on Google. I promise you, because I go through certain patents, but reading a patent itself is a challenge. If you are able to read a patent well, you will definitely able to draft a patent well. So a big thanks on behalf of Pacific University, Pacific Medical University, and IPR Cell Paher University. We'll keep on organizing such events in the near future also, and we would like you all to again join with us with certain new dimensions on intellectual property. Thank you so much. Dr.
Thank
Ritesh,
you.
we can conclude the session.
Yeah, sir. Thank you very much, sir. So it was, we thank everyone for joining us, and with this word, have a nice weekend.
Sir, Dr. Ritesh, are we sending some certificate?
Sir,
link or-
I have already shared the downloaded link on chat box.
Okay.
So,
Jay sir and Ritesh sir, it was nice presentation, and thank you very much for such nice workshop today.
yes.
Thank you, sir.
It was all your support, sir.
Absolutely.
It is all because of your pain and hard efforts.
No, sir, it was all your efforts. Continuously, you are all supporting the activity, the way you are driving
And
things.
I must thanks to every participant, those who are attending till last, 18 participants. I should praise them that, really they put their hard efforts and they are staying till last moment. And I understand that the people are really want to learn something.
Absolutely, absolutely. And the presentation was also full of knowledge. sir.
Amazing. It was amazing. It was amazing.
It was
really.
amazing. And,
Really, really.
and it was matlab, like the presentation was in a way that a single person could understand.
Yes.
And
yes,
sir, we people read.
And you have
patent
taken,
fee from-
like Ritesh Raj also and Pratik sir, both have taken all the aspects of IPR, how to
Absolutely.
file, and like what have to be taken care when you are filing the patent. Everything is explained very well manner.
Thank you,
So-
sir.
So, sir, we should
Thank you.
conclude now.
Yes.
Thank you, Dr. Ritesh.
Yes, sir. So we will leave for the day. So have a nice weekend. Bye bye.